Good morning. I will commence these proceedings by first making a ruling in respect of the applications received for cross-examination. Having considered the applications to cross-examine the identified witnesses, the objections filed and the responses given, further considering that the contemplating cross-examination is deemed necessary in the interest of the functions of the Commission as required by Regulation 11 of the Commission's regulations, I grant both SERI and the South African Human Rights Commission permission to cross-examine the identified witnesses. This permission is obviously subject to reasonable allocation of time and relevance. That's my ruling.
The Commission, please.
Mr. Semenya?
That chairperson would then have us recommitting Mr. Makola to his previous oath and therefore ask for SERI ICF to commence with their questioning.
Yes. Mr. Makola, you are reminded that you are still under your former oath.
It's noted, Chair.
Mr. Brickhill?
Good morning, Chair, Commissioner Mabena. Chair, in relation to the allocation of time, we envisage requiring more or less until lunchtime. That's my estimate, if that would be considered reasonable at this stage.
Yes. And that's not taking into account the fact that we've got to adjourn for tea.
Indeed so, Chair.
Yes.
Indeed so. Of course, all of these, it's always an estimate and it depends on the exchanges with the witness, but that's our reasonable estimate.
Yes.
Chair, just in terms of some housekeeping, we have, there are a few additional documents. There are two cases that we have added to the SERI Law and Policy Bundle. One is the Constitutional Court's judgment in December in the Commando matter concerning temporary emergency accommodation in the city of Cape Town. And the second is the judgment that the witness was referring to yesterday in Leray, the Johannesburg High Court judgment concerning the De Villiers property.
Yes.
And we've added that to the bundle. And so those are now included in the bundle that is before you, Chair, and before all of the parties in Policy File 3. It's a slim file with a handwritten annotation. So that is the one addition. The second, Chair, which, and I believe there are copies, is a short supplementary affidavit of Mr. Mahlangu of the ICF regarding the issue of ESP registrations in the relevant buildings. It is, the affidavit runs to some 6 or 7 pages with 7 short annexures. It's not a bulky document. Chair, if it's appropriate, I'll deal with it when we reach it. But I just wanted to draw attention to the document. We will ask at that stage
we
that
have
it
the
be
document.
admitted. Thank you, Chair. As I say, we'll reach it in due course. Mr. Makula, good morning. We met briefly just before the commencement of the proceedings. I will be exploring some areas with you. It's our view as SERI and the ICF that there are many areas of commonality between the City of Johannesburg arising out of your evidence and the positions that we have taken in these proceedings. There are some areas of divergence too, And in the course of my questions, I will explore some of those areas. I want to begin then with your confirmation of the city's appreciation that the context includes a housing crisis. And you confirmed in your testimony yesterday that the city understands that there is a crisis of affordable housing in the inner city of Johannesburg. Is that correct?
That's correct.
Now, in addressing that crisis, the city's constitutional and legal obligations are relevant. I don't intend to take you through the case law or deal with what those legal obligations are, but what is relevant, we submit, is the city's high-level understanding of its constitutional obligations. I want to put certain propositions to you, and you can please indicate whether you agree that the city bears the obligations that we would suggest that it does. To begin with, an overall obligation that the city bears under the Constitution and relevant legislation to provide housing, especially for those who cannot afford. Not an unlimited obligation, subject to available resources, but the city is required to take reasonable steps to realize the right to housing, including where necessary providing housing. Would you accept that that's a fair understanding of the city's obligation?
Yes, I accept that is a fair obligation on the city side in relation to the Constitution, yes.
And that in the context of that obligation, there is a specific obligation to prioritize the people who are in the most desperate position.
Yes.
And this is an aspect you spoke to yesterday in your testimony, that where an eviction takes place and it will leave people homeless, there is an obligation on the city to provide alternative accommodation, temporary alternative accommodation.
Yes, there's that obligation, yes.
You didn't expressly speak to this issue yesterday, but one of the constraints on evictions is that there may be no eviction without a court order in terms of the Constitution. Do you accept that?
Yes, we accept that. I did touch a bit on part of the value chain will include the legal team conducting the actual legal work before we proceed to those buildings. I did touch on that. Of course, I even highlighted the Constitutional Court judgment that obviously re-emphasize that obligation on the city to follow due process before you proceed to do evictions. Yeah.
Indeed you did, Mr. Makula. You highlighted the Blue Moonlight judgment, which confirmed that obligation to provide alternative accommodation arises even where the eviction is from private property.
That's correct, yes.
You also spoke to processes of evacuation, and you highlighted the Moth building and the plans for Vannon Court and the other two buildings, the city's plans in that regard. And I want to put it to you that the city, where it conducts an evacuation of that sort, this is simply a form of eviction based on safety and also requires a court order.
Yes, I can confirm, and I can also confirm that those properties we had identified, the legal work had already been done, and we had made submissions to the court in terms of our operational detail and our readiness, which is part and parcel of the improved value chain, to ensure that we do not find ourselves in the other side of the law.
Yes. It's our understanding that an order was obtained in relation to the Moth building.
Correct.
Relatedly, Mr. Makula, where such an evacuation, such as the Moth operation, takes place, the city would accept that it bears an obligation to provide temporary alternative accommodation if the people will be left homeless by that evacuation removal. You would accept that?
That's we accept it, and hence we make provision. So the reason there's the delay in the execution is that part of the planning and part of the value chain is we do have to identify alternative accommodation on a temporary basis. But of course, the value chain is we need to find a permanent solution hence rental and finding social rental facilities that we own to move those that can afford becomes a long-term intervention.
Yes, thank you, Mr. Makola. And you explained the challenges around achieving that in relation to the moth building residents yesterday.
Yes, I think the challenge did not happen in the temporary accommodation, as it were. The challenge was once we had moved the occupants of the moth building into the identified social housing facilities in Vleerhof owned by Joshko. It's the backlash that came from the residents in Soweto that became an issue. Of course, we did not anticipate when we did the assessments and the consultation process that we'll have that as a challenge.
Thank you, Mr. Makola. Finally, at this high level of principle and obligation, you referred yesterday in your evidence to the city's policy on corridors of freedom. And as I understood your evidence, you accepted that the city must provide affordable housing in well-located areas in the inner city and not merely or only on the periphery.
That's correct, yes.
And you may be aware of the Constitutional Court's judgment in the Commando case concerned the city of Cape Town, not Johannesburg, delivered in December. But it broadly confirmed this obligation and held that the city of Cape Town's policy of not providing TEA in the inner city was unreasonable and unconstitutional. I'm not sure if you're aware of the judgment.
I am aware of the judgment. We have discussed that with the team because obviously it had impact on our operations and our ability to achieve the ideals of the corridors of freedom, which is the city's strategic plan and policy to obviously settle people within the inner city because they are benefit both for the city and the citizens. I mean, the example I made was if you are living in Orange Farm and you work in Standard Bank, as an example, in Harrison Street, you spend bulk of your earnings on transport. And yet on the flip side, as the municipality, we introduced the bus rapid transport to reduce the cost of transport. So getting you residing in the inner city reduces that burden on the citizen, but it also leaves a lot of their salary in their pockets to do other things, whether it's school fees and all of those things. So hence the development of the corridors of freedom.
Yes. And at least in relation to the city of Johannesburg, the city's policy has been to develop TEA and to provide it in the inner city, and the city has done so, correct?
That's correct. So if you look at this operation that we did in December, we had actually planned to do that operation in November, but when we identified alternative accommodation, we looked at areas of Orange Farm, Langlaagte. We considered that those might be too far for the residents who are already living in the inner city, and hence we had to revise that plan to look at Vleerhof as being the closest if they were to travel for work or business in the inner city, and that's why we took that long. But those are considerations that we looked at during the planning phase of the operations and part of the development of the bed building strategy.
Yes. And as I understood your evidence, similarly in relation to affordable housing and social housing, the city's commitment is that at least some provision must be made in the inner city.
That's correct.
We will return to the question of TEA and other challenges in its provision and the relationship to affordable housing in due course. But I wanted to set the scene with those high-level principles. I should indicate that in relation to all of those principles, SERI and the ICF make common cause with the city in relation to your understanding of your obligations and those high-level policy commitments. If I may then deal with a more specific issue, and it's the question of the De Villiers Street property that you addressed in your evidence yesterday. And you explained the city's intentions and plans in that regard, and you also referred to the High Court proceedings that followed and that ordered the return of the building to the owner. I just want to touch briefly on that judgment just for completeness. And we have provided the judgment in the file that is to your left, which is policy file 3. And it begins from page 1567. The first case that you will find in that file is the commando judgment that we were discussing a moment ago. The second is the Johannesburg High Court judgment in the Leray Investments matter. Do you have the judgment, Mr. Makula?
Yes, I do, Chair.
Okay. And it appears that you were cited as the fourth and fifth respondent. The fourth respondent in your official capacity, and the fifth respondent seemingly in your personal capacity. Is that correct?
That's correct, Chair.
Now, you testified yesterday that the court ultimately found against the city and required that the city restore possession of the building in De Villiers Street to the owner, Leray Investments.
That's correct, Chair.
There were just a few aspects then of the judgment that I wanted to highlight. Now, the first aspect that I wanted to highlight, which appears from paragraph 4, and read with paragraph 2, but let's start with paragraph 4, is that the notices of the alleged breach of bylaws were issued by the city on 21 February, and the eviction took place, that's in terms of paragraph 4, and the eviction took place on the same day, on 21 February. Is that correct?
That's correct, Chair.
And then if I could take you to paragraph 7 and following. The High Court judge noted that the city relied on section 98.3 of the bylaws, and if we move to paragraph 8, we have the court's interpretation of what section 98.3 of the bylaws permits. And the court accepted that section 98.3 permits the evacuation or closure of the relevant premises. And that means that the premises can no longer be accessed or used by the general public. But it continues on page 1570, paragraph 8. It does not mean that the city may deprive the owner of possession of the property, thereby making it impossible for the owner to do anything with it, including taking steps to comply with the bylaws. So, the High Court, and perhaps for completeness, if I take you to paragraph 11 over the page, the High Court concluded at paragraph 11, even if section 98.3 of the bylaws could be read to authorize excluding Leray, the owner, from its property, and in brackets, it cannot, the city did not lawfully exercise such a power in this case. So the court ultimately held that the city's conduct was unlawful. It had exceeded what section 98.3 of the bylaws permits. Would you accept that?
Well, Chair, I having been briefed on the proceedings of the case, And the briefing from the legal team was that, of course, the city was not given adequate time to present its case, but based on the judgment and what's in the document, one would summarize that the court felt that the city did not act within the confines of the law.
And the city, to be clear, has not appealed this judgment. It has effectively complied with it.
We have complied with the court judgment, but of course we're still pursuing the owners of the building for the building to comply.
Yes, I understand that. So on that point, could I take you to paragraph 12 of the judgment, where the court held, it follows from all of this that the removal of Leray and its tenants from the property was unlawful from the outset. Leray was spoliated. It is trite that a person spoliated of property is entitled to retake possession of it before the lawfulness of its possession or use of the property are explored. In other words, and this is the part that I want to draw your attention to, in other words, the city was not entitled to illegally evict Leray from its property and then bargain the terms on which Leray would be allowed to retake possession. So as I understood your testimony yesterday, what the city sought to do was to remove the owner and shut down the building, and then set as conditions for reoccupation that the owner must comply with the bylaws. And the High Court is holding that here that the city was not entitled to do so. It was not entitled to evict the owner, bar them from the property, and then bargain the terms on which they would be allowed to retake possession. So what I'm putting to you is that what the city intended to do here was found by the High Court to be unlawful.
Chair, as I indicated earlier, that the intention of the city, one, was not to conduct an illegal evacuation. What the city merely responded to was a lot of illegal, my apologies, was a lot of illegal activities in the property. One, when we first entered the building, there was alcohol in the building, and we requested for the liquor license from the manager of the property. The license that was provided to the city was a 2023-2024 license, which had expired. And in terms of the Liquor License Act, you have to display the current license in order for you to trade in alcohol, which is one of those bylaws that we enforce. Following that, as we moved into the building, into the back of the building, we also discovered that there is a development that is happening in the back of the building. We proceeded to request for building plans that have been approved from a development planning perspective, and those plans were not furnished, and there were workers who were working in the building with heavy machinery without any ventilation of sorts. And we asked the manager, please provide us with the approved plans for this development, that the construction to happen. That was not provided. We then proceeded to want to issue citations to the manager, who then since left the building to call the owner, and the owner did not arrive. And I suppose the challenge that I raised, based on the feedback given from the legal team, was that the team was unable to present that to the court for one reason or the other, and therefore the court arrived at this judgment. But the intention was to enforce the bylaw. The city never went to that property with the intention to not be lawful or remove or evacuate the occupants unlawfully. We were simply conducting an operation to enforce the bylaw, and we found a lot of illegality. And of course, given the matter that brings us here, we did not want to lose any further life and not take action when the building had a lot of unlawful activities that were happening in that. So in that context, of course, the court made a ruling based on the submissions, and we accepted that. But we're still adamant that the building must comply in order for them to resume with their business. We did not confiscate the property. We simply said you cannot operate if the building is not compliant with the bylaws.
Mm-hmm. Yes, we've understood your evidence on what the city intended, Mr. Makola. Just for completeness, in paragraph 13 of the judgment, the court holds that the city acted substantially beyond any lawful power it could reasonably claim to have, It ought to have appreciated this from the outset and to have restored the property to Luray at the first opportunity. Instead, the city insisted on pushing an application to which it must have known it had no defence to a hearing, and for that reason a punitive costs order was plainly justified. So the court also granted costs on a punitive scale. Mr. Makwala, we are not suggesting that the city was acting here in bad faith. It seems clear that the city was attempting to enforce the bylaws. But what I want to put to you is that the city, in doing so, was overzealous. It went beyond its powers, acted beyond its powers. Do you have any comment in that regard?
I don't necessarily agree that we went beyond our powers, Chair. As I already explained, the intention is to ensure the building complies, and we followed the prescript of the law in terms of the Fire Brigade Services Act, which provides the chief of EMS who was on site to shut down any building if life is threatened. Two is that, of course, we had a building that did not comply with our building plans, bylaws, which, of course, once you're on the ground, and I think, Chair, it's important to explain that the theory and practice are always different. So when you are on site and you are on scene, the circumstances that you find yourself in at the time are different from when you are in a courtroom. And we did attempt to have a conversation with the owner on the spot. The owner did not arrive. I made several calls. There are a number of people that approached me on site, and I said, let the owner come on site so we can have this conversation. The decision to close the building really came at the end once we realized that the owner is not willing to get the building to comply, and therefore the only way to safeguard the lives of the people in the property was to close the building until such time that, of course, it complies.
You accept that there are limits to the city's powers when it does this sort of thing in terms of evicting people from a building?
Absolutely, I accept that.
And you've attempted to explain why the city acted as it did, but the High Court held that the action was unlawful. Ultimately, you accept that finding.
Accept that. Hence, we complied with the order of the court, but still insist that compliance, in order for the operation to resume, must be done by the owner of the property.
These issues of compliance, enforcement of bylaws, and respect for rights in the process of doing so are issues to which we're going to return later. But I do want to put it to you that the city's conduct in De Villiers Street appears to have been motivated, at least in part, by an attempt to show the public that the city is cracking down on bylaw compliance. What would your comment be in that regard?
I would disagree with that proposition, Chair, on the basis that we don't only just do our work to show to the public. As I say, part of my functions in the city, in my past life, I was the head of emergency services, and my job was to do compliance in all the buildings on a regular day, whether there's a special event or not. It became my job every day to go out to inspect buildings, provide a report to my superiors, and at some point approve those reports. So there was no public relations stunt that we were pulling. As I said, Chair, all we did was, in order to achieve maximum benefit, we took a decision as the executive to change the deployment strategy. As an example, I said we have 7 regions, and at all material times, we have officers doing inspections in the 7 regions. However, it doesn't give us the maximum impact that we require. So as the head of operations, I make a decision that let's move all our resource into a single region over a longer period so we can see maximum impact in terms of that work. So it's not work that gets done on a special day, it's work that gets done every day. As we speak now, every day there are officers on the ground doing inspections. There are JRA officers fixing roads on a daily basis. There are economic development officers enforcing the bylaw, the traders' bylaw on a daily basis. So it's not as and when or if there's a spectacle that we want to show. So I wouldn't necessarily agree with that proposition, Chair.
We can return to that more broadly. Let's move away from the De Villiers property. I want to touch briefly on TEA, which you testified on yesterday. We intend to deal with this in more detail with Mr. Nkoane. I imagine you would agree that it would be more fruitful to deal with it in detail with him. But I'll deal with TEA just at a high level with you. The first proposition I want to put to you is that in general, the city's TEA facilities in the inner city are fully occupied.
That's correct, Chair.
I want to put it to you further that the TEA that is available is insufficient for the need in terms of court orders requiring alternative accommodation. The existing facilities are full. What is there is currently insufficient to comply with all of the court orders requiring TEA to be provided.
Agree.
I also want to put to you that the TEA facilities, for the most part, and with the possible exception of Fraser House and Albert Street, have fallen into disrepair at this stage. They're in bad condition.
Agree, Chair.
And I want to put it to you that those TEA facilities have not been adequately maintained in the recent years by the city.
We accept that, Chair.
And you spoke to this issue yesterday also, but I also want to put it to you that one of the difficulties is that there is nowhere for the people who are currently residing in the TEA to go because of the lack of affordable housing in the inner city.
That's correct, Chair.
So the system becomes log-jammed, those people remain in the TEA indefinitely, and the TEA isn't available to accommodate new people who may need it.
That's correct, Chair. Hence, in my response, we then indicated that we are exploring alternative options. Option one being releasing some of these buildings that we evacuate as they are to the private sector, of course, following the sale and execution of those properties, or releasing them to the market, the piece of land for redevelopment, because we accept that as the city of Johannesburg, we may not be able to provide affordable housing, but in collaboration with the private sector, we are able to. Hence, we referred to writing to council for council to provide those delegations to the accounting officer so we can fast track the process of releasing. And part of the last step of the value chain that I spoke about in the bed buildings is that different approach, that let's release these properties to the private sector who have shown some interest in contributing or going into the affordable market within the inner city. And that is how we are revising, because of course we accept that our current properties are not are unable to accommodate the evacuation orders. Again, if you look at the 4 buildings that we've identified in those operations, they get delayed simply because we have to find alternative accommodation before we move into those operations. And those are the considerations that we look at before we act.
Thank you, Mr. Makula. And as I understood your evidence, it will also involve an emphasis, instead of placing people in temporary accommodation, recognizing the need to provide permanent accommodation from the outset. Did I understand you correctly?
That's correct, Chair. So that is the proactiveness of the strategy that we spoke about, is that instead of finding temporary TAs, we find a permanent solution. But of course, we tested out for 6 months, which was the approach in flare-off, that we look at the behavior and the payment patterns of those communities that we move to flare-off. And if we find that their conduct in that 6 months is proper, then we allocate those units to them on a permanent basis. And those that can afford, of course, will then have to find further alternative accommodation. And there are pieces of land that we own where we then want to build chromodeck structures where we can then accommodate the people that can't pay. And of course, those others, we will then move them into the periphery of the city, which is the last option. We generally don't want to move people outside of the inner city with the understanding that their livelihoods is within that space and they'll obviously want to continue to live, work and play in the inner city. And I think that's a proactiveness that we've brought in over a period of time.
Mm-hmm. These shifts in relation to the city's approach to TEA following evictions, do you envisage that they may require some review and changes to the city's existing policies, such as the city's TEA policy?
That's correct. We agree that we may have to review the TA policy, yes.
Okay. It is in our bundle. I don't intend to take you there at this stage, but rather to move on to a different issue. That's the extent to which I wanted to deal with TEA with you, Mr. Makula. I want to now come to maybe a semantic matter, but for SERI and the ICF, it's a matter of some importance on which experts have already testified and other witnesses have given evidence. And it's the term hijacked. It's a term that you used in your written statement and that you've used also in your testimony yesterday. And if I could take you to your written statement, which is in the M&S blue file.
Which page?
The very first page of your statement and paragraph 3.
Page, we have
Page 39, Chair.
29, 30?
39. 29.
29 is the first page. No?
It should be 39.
So, my apologies. 39, yes.
So paragraph 3 is where you explain what you understand by hijacked buildings. Paragraph 3 reads, the purpose of this witness statement is to provide insight into the surrounding circumstances regarding the prevalence of bad and hijacked buildings within the city. And in the second sentence you say, hijacked buildings refer to properties that have been unlawfully occupied or taken over by individuals or groups without consent of the rightful owner, referred to in the city's bylaws as problem properties. So link it to the term problem properties in the problem properties bylaw. But effectively what you say you understand hijacked buildings to mean is properties that have been unlawfully occupied or taken over by individuals or groups without the owner's consent. And that's the explanation that you give. Now, in fairness to you, the term hijacked buildings is used in the terms of reference of this Commission of Inquiry. But several of the expert witnesses and the SERI and ICF witnesses testified that they consider the term to be unhelpful and problematic. And I want to put to you certain propositions about the term hijacked. The first is that this term hijacked building has no legal meaning. It's not a term that appears in legislation. Can you respond to that, please, Mr. Makula?
I suppose it may not be in any legislation, but it's a general term that's been used both in the city and I dare say in the country to identify this problem, but it may not be in any legislation.
We would accept that it has been used by the city, certainly. Taking then your interpretation offered in paragraph 3, I want to put to you certain scenarios. If I'm renting my flat and I'm late with my rental and my landlord terminates my lease, but I don't leave the property, is my home then a hijacked building? It would then be unlawfully occupied without the consent of the owner.
Not necessarily, and I don't think the explanation defines it in that way, because I think the hijack term talks about firstly, let's accept that all the occupants of the buildings are not necessarily identified as hijackers of the buildings. The people who are generally identified as hijackers is those that are paid rental by the occupants in the building, who are not the rightful owners of those specific properties. So in the proposition that you put, if you own the flat, you did not hijack the flat. You were there illegally through a contract via the rightful owner of the property. However, once the ownership of the property changes hands from the rightful owner to an illegal owner, that, of course, brings rise to the term hijack building, because you are there legally through a contract. However, the person you are now paying is not the rightful owner. And I think that's in the main the problem statement that we identify in the bad buildings, is that it doesn't necessarily mean all of those properties cannot be restored to their owners. It's just that the occupants are paying the incorrect person at the time, because it's very clear the evidence is there that all of the people we remove are able to pay. And this we identify through the assessments that we conduct through human settlement at Georgeco before we implement the eviction. And all of them have confirmed that they pay. Some of them are employed, and therefore they earn salaries and they're able to pay. The only challenge is that once the owner of the building exits and someone else gets paid, other problems then arise in the form of illegal connection, non-payment of the city property rates, including trading services.
Mr. Makula, if I can then put a scenario that's perhaps a bit closer to the facts of before the Commission. If the owner abandons the building, with tenants having lived there up to that point, the owner abandons the building and disappears, stops servicing it, would that constitute a hijacked building?
Well, so it depends whether the owner willingly agreed to hand over his property to the next collecting agent or management agent, and makes that agreement to hand it over to the next owner. But our investigation revealed that more often than not, the owner leaves the property because either they've been coerced to leave the building, or the occupants have just not been paying their rental to the owner, but have been paying another person, and that then creates the challenge.
I'm putting to you a specific scenario, and it's arisen in the facts of this Commission. The owner abandons the building and disappears, leaving the tenants living there, and the tenants then take steps to manage the building and look after it. Is that building hijacked?
Not necessarily, may not be hijacked, but it may fall into the same category as a bad building, because the maintenance and the upkeep may not be done. So not all buildings are hijacked, and not all bad buildings are hijacked. So they may be bad in the state that they not been kept up to the normal requirement in terms of repairs and maintenance, but they don't necessarily mean that they are hijacked.
So when you use the term bad building, you're referring more to the safety and the conditions of the building.
That's correct. Yeah.
So a building could, for example, you were referring to buildings in Sandton, and yesterday there could be a building in Sandton, the owner is known, present, but the building has fallen into bad condition, it's unsafe. That wouldn't be hijacked, but it would be a bad building.
Yes, sir.
I want to put one more scenario to you. If the building is a TEA owned by the city, and the city stops actively managing the building, and the building falls into disrepair, the occupiers stay beyond the 6 months that they were initially offered, is that building hijacked? Is that TEA hijacked?
No, it wouldn't be hijacked, but if the conditions are in a bad state, we'll then refer to it as a bad building.
So I want to put it to you that this term hijacked, as our experts testified, is a pejorative term. It implies criminality, and it imputes this criminality to everyone in the building.
Not necessarily. I agree that it's a bad term, yes, but it doesn't apply to the occupant. It applies to the individual who decides to take ownership of the property without proper handover or even paperwork or transfer cost being given to the rightful owner, which is what we find in majority of the hijacked buildings. The owner takes rental, accepts rental, but is not the rightful owner of the property. Even if the owner would have abandoned that building, someone else appoints themselves as the owner of the building and collect rent on behalf of the occupants, but does not pay over to the municipality or even reinvest in the upkeep of the property. So I don't think it applies across the line. I guess it applies to specific properties that are in that space. Yeah.
It applies to specific properties.
I'm saying it applies to those properties where the owner has been evicted illegally by whoever is collecting rent at that time.
And it would be presumed to apply to everyone living in that building?
No, not necessarily. As I said, it's not the occupants who have hijacked the building. It's the person who is now paid the rent, who is not the rightful owner of the property, that the hijacked word would be applied to, and not necessarily I don't recall that we would have said the owners or at any of our papers of arguments that we made that the owners or the occupants have hijacked the property.
As I understand your evidence then, Mr. Makola, the city's central concern is with people who unlawfully collect rent. That's the real concern at the heart of this term, hijacked.
Well, it's one way to look at it. I think the full view is to look at the entire state of the property, because what is our responsibility, as you've indicated? Our responsibility is to enforce the bylaw, and we enforce the bylaw to the owner of the property or the resident, whether even if it's a residential property. So we deal with the owner of the property to ensure that, because we agree and accept that there's a contractual obligation between the occupants and the owner, and the city cannot interfere between the contractual obligations. But immediately there is no rightful owner of the property, of course, you have a different scenario then, but you still need to enforce the bylaw from what we are obligated to do as the municipality.
In your statement, you linked hijacked buildings to unlawful occupation. Do you understand all unlawfully occupied properties to be hijacked, or it's only those where someone other than the owner is collecting rental?
I think, Chair, we restrict that to the properties where the owner is no longer collecting the rent from the occupants.
And
so hence I had said those, so either you use bad buildings or hijacked buildings, which bad buildings will apply to the owner is there, but they are not maintaining the building. Hijacked building refers to those buildings where the owner has abandoned for one reason or the other, but the occupants remain occupying. And that is why, if you look at our operational plan, when we conduct it, we'll go and do an assessment of who is in the property and who's in the building, so that we can arrange alternative accommodation and, where possible, find permanent social housing or affordable housing for the occupants. Because otherwise, if we didn't care about the occupant, would simply evict them and put them outside, leave them there. But that, of course, will be against the law and against the spirit of what we are trying to achieve as the municipality, which is make sure that the city is livable and everybody is able to find affordable human settlements.
Mr. Makola, one of the other experts, Professor Cousins, testified that, according to research that he has done, a majority of the people in our country live on land to which they don't have a formal right, in urban and rural areas, more than 50% of the population of the country. That makes those people all potentially unlawful occupiers. In light of that evidence, do you see the difficulty, do you accept the difficulty with characterizing buildings in the inner city as hijacked, where they're merely unlawfully occupied?
Yeah, Chair, I think as I try to separate the two and allocate hijacked to those that are indeed hijacked, because we are not saying all buildings in the city have been hijacked. We are clear and specific on those where the ownership has changed hands unlawfully so. The issue about the research in relation to people who are in the land that they don't own, I mean, that's a totally different matter altogether, given the history of our country and where we are and where we come from. But in specific to bad buildings, I think those buildings have been hijacked, and we identify them as such because the matter is the owner. Because, as I say, the people in the properties or the occupants are paying rent to someone who does not own the property. And therefore, there has to be a term that we use for that specific. And we are not saying all the properties are in that state.
I want to put it to you, Mr. Makola, that the term hijacked buildings stokes up hostile public opinion against the residents of the inner city. Do you have any comment in that regard?
I wouldn't want to comment on that. I think it's a view that different people may hold, but I think as a public official, I may stick to hijacked buildings being properties that are unlawfully owned by a person who doesn't have the title deed to the property, neither a contractual obligations. I wouldn't want to comment on what the general public would use that term as.
Mr. Makola, I'll put it to you then that it's our submission that the term is vague, and with respect, your evidence hasn't helped to clarify its meaning. The term is pejorative, and that it should be abandoned by the city. And that at the end of these proceedings, we will ask for a recommendation to that effect. Have any comment in that regard?
Chair, I wouldn't necessarily object to it. If the term is not a legally sound term and it doesn't give the meaning, which I hold a different view, of course we are amenable to working with yourselves, the academia, and all other involved to find a suitable term that defines the problem statement, because I think the main issue is you do want to define the problem statement for what it is, not because of a public opinion, but because the solution must go towards the heart of the problem. So if you define it in any other way, you are likely to then come up with solutions that don't go to the heart of the challenge. And I think when it comes to hijacked or bad buildings in the city, it's about providing a affordable social housing or affordable rental to the citizens of the city in Region F in particular. Of course, not discounting the housing backlog that we have. And I think that's the biggest crux. And that, of course, comes with its own other challenges. And I think that's where we should spend a lot of time and energy resolving the issue of affordable housing and sustainable human settlements.
Mm-hmm. Mr. Makola, we appreciate that response. If I put it to you then that the focus really ought to be on the people rather than the buildings primarily, how would you comment?
I would completely agree. So if you look at the city's response, it's always been about the people. How do we find alternative accommodation for the people? The corridors of freedom you talk about, the specific focus is about settling people within the business nodes, but also making sure that they work, live, and play in the areas where they work. As an example, I made the example about the reconstruction of Bree Street as an example, or Lily and Goy. We've closed some of the lanes to reduce the lanes so people can live in that area and provide social housing, provide social amenities, provide a park even in the inner city, because we don't believe that that can be done. We believe it can be done as the city. Hence, you find that in the policies of the city through the growth and development strategy, which is the long-term strategy of the city. It's not a term that we just developed now. From 2011, we're very conscious as the city leadership at the time to relook at how people resettle, particularly in Region F, and try and not push them out to the periphery because it has its own other challenges and complications moving forward.
Thank you, Mr. Makola. I'll return to some of these issues later after the break in terms of how those objectives are best achieved. Chair, I see that it's 11:15. If it would be
Yes.
convenient, this is a suitable time to pause.
We'll take an adjournment and reconvene at 11:30. Yes, Mr. Bricky.
Thank you, Chair. Commissioner Mabele. Thank you, Mr. Makula. I'm going to move to a new topic now. Again, something that you covered yesterday. It's the new bad buildings strategy that you referred to in your evidence yesterday. And you referred to some workshops that were held. Just in perhaps not much turns on it, but you suggested that Seri may have attended one of those workshops. I attempted to clarify that overnight, and my instructions are that Seri, as such, wasn't invited and didn't attend any of those workshops, although we're aware of other civil society actors who may have attended, but perhaps nothing turns on it. If we can deal with this bad building strategy then, and there's a difficulty here, Chair, which we've raised with our learned friends for the city. If I can take you to, I think it's page 107 of the blue file, the MNS file. That is annexure ON5. It is the fifth annexure to Mr. Nkwane's statement.
107.
107, Chair. It's a blank page, indeed.
It's a blank page.
It's a blank page. So it appears that all we've been provided with at this stage is that blank page and not the actual bad building strategy. We wrote this morning to our learned friends for the city, and I understand that they're making efforts to locate the document. As such, I'll be somewhat limited in dealing with it with you, but there are some aspects of the strategy that I wanted to touch on, even at this stage when we do not have the document. First, perhaps you can confirm whether the bad building strategy exists as a single document at this stage.
I can confirm, Chair, that it is a document that exists. It's a strategy that I personally developed, and the content thereof I'm aware of, and we've submitted that to the political executive to take note of that. But parallel to that, we've proceeded to do implementation of the same strategy, Chair.
Yes, so thank you, Mr. Makola. So my understanding is that it was developed during the course of last year, but that the city has already begun to implement some aspects of it.
2023, Chair, is when the development of the document was started. I did, during my testimony, indicate that when I took over office, one of the tasks that my boss gave me, the former city manager, was to find a way to manage the phenomenon of problem property in a much better way. So 2023 was the beginning of the development of the strategy.
And is the strategy now in final form, or is it still a draft being subjected to further engagement within the city or externally?
So the final workshop that you referred to was the final workshop with external service providers or external partners. So the document is now final. What we've been doing is sending it through the different governance committees for noting. But administratively it has been adopted and accepted, hence we've been able to do implementation of the strategy and the change in the operations as opposed to before the strategy.
And by whom was it adopted? Was it adopted by you as acting CEO?
No, it's adopted by, we have the Executive Management Committee, which is more administrative and accepts strategic documents and approves those documents. From an administrative perspective, it has been adopted and accepted, hence we are implementing. What we are simply doing now is we are circulating it through the different committees, your oversight committees, for noting, to note, and not for general approval, and we do want to send it to council for council to note as the final decision-making body in council, but to note.
Is the executive committee that you refer to different from the mayoral committee? Has it been
Completely different.
Has it been approved by the mayoral committee?
It has not gone to the mayoral committee. As I said, before it gets to the mayoral committee, it has to go through different technical cluster committees, which are more administrative. Then it goes to the sub-mayoral, which is chaired by an MMC, then goes to mayoral committee, and then goes to council. But mayoral committee has received a presentation on the review. So the mayor has endorsed the approach, and hence we were able to proceed with the implementation thereof.
Okay. But in terms of those further steps, it will be submitted for noting to all of those bodies.
It will be
that
for
you mentioned.
noting, yes.
So as far as the approval is concerned, it's the approval of the executive committee.
It's an administrative document. It's not a policy document because, as you know, mayoral committee approves policy, but the strategy and operational plans are approved administratively. So the accounting officer has those delegations. But if it's a policy and it's a change in the city's policy, it will have to go through council. Of course, it goes through mayoral committee and all the other committees. So in essence, you are taking it to the other committees so they can conduct oversight on the work that the administration would have done in relation to the bad buildings, as it were.
Okay. As I say, we may need to return to it either with you or with other witnesses in terms of the actual content. I'm just focusing on the process for now. The name, Bad Buildings Strategy, or I believe that Mr. Nkwane's statement refers to it as a Bad Buildings Program. Which is it? What's the correct title?
It's a bad building strategy.
Bad Buildings Strategy.
Yes.
Okay. The city previously had a Bad Buildings Program from 1999 to 2007. Do you recall that?
Yes, it's a program similar to the ICHIP program, but I think the limitation there is that it focuses on just dealing with the buildings and not the holistic view of what is the problem statement and how you then resolve the problem statement holistically. As an example, you look at removing people from bad buildings into alternative accommodation, and it kind of limits, or it stops at that point, but doesn't talk about livability and livelihoods of the people who are in the inner city, which may also refer to taking people from the inner city and settling them in the periphery, which is something that we are saying it shouldn't happen because you come to the inner city for a specific reason, and therefore you should not be removed to the outskirts of the city, as an example. So I think I made reference to ICHIP yesterday that it does emphasize the point that social affordable housing is required, or social affordable housing, whether provided by the state or the private sector, is what ICHIP was focusing on. So what we are essentially saying in the bad building strategy is that over and above providing social and affordable housing, you also must provide social amenities. You must also provide commercial activity in that space so that people can also thrive in the inner city.
Mr. Makola, thank you. Again, we don't yet have the document, but you seem to have identified some of the criticisms of that older 1999 Bad Buildings program, that it was simply focused on buildings and clearing buildings, on policing and enforcement, rather than on the livelihoods and rights of the people living in the buildings. As I understand you, there's been an attempt in the new Bad Buildings strategy to address those previous shortcomings.
That's correct. So if you also go into, and hence in my statement, I talk about the rejuvenation or revitalization of the inner city. Because if you look at that plan, it talks about a precinct approach, but it's a whole 360 sort of approach, as opposed to, and that's why we say it's more proactive as opposed to reactive. I think the previous plans were reacting to an environment and trying to deal with that environment and not looking at what is the actual cause and then deal with the cause of the problem, as opposed to dealing with the symptom that comes as a result of bad buildings being created. And I think, we just had a discussion about whether it's hijacked or not, but
we're past the terminology.
So,
yes.
so it's important to get to what is the root cause so that the solution addresses the root cause and not the symptoms of the challenge. And I think that's what we are really we are attempting to do with the bad building strategy. And of course, the proof is in the implementation, whether that works or not.
Yes, it's a new strategy. By the root causes, you would be referring to the underlying housing crisis, the lack of affordable housing, inward migration that you talked about yesterday.
That's correct.
If I may then ask, in terms of the other witnesses that the city is making available, are there other officials who've worked on this strategy with whom we might deal with the content if we don't get an opportunity to do it with you?
Chair, as I stated, the stakeholders, there were internal stakeholders. Human Settlement is a stakeholder, Group Legal, Group Forensic, Johannesburg Property Company. So I do believe that a majority of the witnesses that are coming will be able to articulate aspects that relate to their actions in the bad building strategy. You recall that we spoke about the value chain, and I think the value chain is nicely described in the document, and each department and entity on their own have a specific task, a role to play, but all of that contributes to the improving the livelihood of the occupants of those buildings.
Okay, thank you, Mr. Makola. I think that's as far as I can take it with you now without having seen the document. And we appreciate that you would have the big picture perspective. Other witnesses may have a perspective on a specific aspect of the strategy. Perhaps we can leave it there. We'll see if the document is made available during the course of the day. If I could then move to another, you referred to what you called an operational plan yesterday, and it's a similar question. Does this operational plan exist as a document? Let me start there.
Yeah, so there is so post-development of the strategy. We then focused on the 4 buildings that we make reference to in my statement, and in addition to that, we've added Florence, and then we've developed an operational plan. So the operational plan basically says, JMPD, how many officers are you providing? This is the date. How many resources do we require in the form of trucks, in the form of officers? How many human capital do we require to assist occupants with removing the furniture? Because we can't expect that families would have the muscle to remove their furniture. And then, of course, as we move them from one area to the other, we take the responsibility to move them. Again, Human Settlement would have done their assessment in advance. The Group Legal would have gone to court to satisfy the requirements of the court that we are ready to provide the evacuation, and this is the detail of what we are going to do on the day. And then once we've ticked all the boxes, then we agree, here's the date, we bring in SAPS, we notify SAPS, we notify Home Affairs, this is the day and this is the assessment, and then they are available on the day of the operation. So there are minutes to the planning. I would chair the initial planning days, then hand them over to the special project unit that is in my office to then run with the logistics. And once we are ready, we'll then inform our political principals on the day. And if they are available, of course, they will then come. If not available, we proceed administratively. So including what time we are starting, when do we meet, where do we meet, at what time we are moving from the venue to the site, and what time do we then close the operation, at which point do we then abandon the operation if required, and if there are risks that emerge, who then deals with those risks on the day of the operation.
Okay. Thank you, Mr. Makula. Mr. Makula, I don't want to curtail your testimony in any way or be seen to do that. You're giving quite lengthy and detailed responses, which may be helpful, but they're going somewhat beyond my questions. My question was whether the operational strategy exists as a document. I'm somewhat conscious of time, but I don't want to be seen to curtail your responses. If you feel that you need to say something in answer to my questions, please do. But I will ask you a series of questions that will get to the other aspects.
Sure.
I now understand that the operational plan appears to be limited to these 4 or 5 buildings. Is that correct?
In the initial stages, yes, those are the 4 that we focused on in the initial, but it's not limited to the 4. It's basically we have a whole list of all bad or hijacked buildings, both owned by the state and privately owned. Last night we sent out assessment teams again to reconfirm the conditions of those that we've identified, so we can then resume with the operations again.
Okay. And that list is part of the operational plan?
That's correct, yes.
Do you recall how many buildings appear on that list?
At the moment, there's about 49, if I'm not mistaken. It's about 49 buildings on that list. That list is compiled from the work that Group Forensic Investigation would have done as part of their work in the problem property bylaw, because they have to go and investigate, do all that work. So that list comes from there and then augmented or supported by Johannesburg Property Company as well.
Okay. And to understand, is the focus of that list on unsafe buildings or on buildings where someone is unlawfully collecting rental? Or both?
The focus of the building is on bad buildings and hijacked buildings.
So is it concerned with safety or with unlawful rental collection, or perhaps with both?
It's a combination, Chair. We are dealing with lawful and unlawfulness, and we, of course, as part of our day work, we also look at compliance to safety prescripts and safety bylaws.
Now again, we've requested this document overnight. We requested it this morning, and we're hoping that it will be made available to the Commission. I imagine you would have no difficulty with making it available to the Commission.
Chair, I have received the request, and I have transmitted the request to the Special Project Unit to make the documents available. We will probably just check around lunchtime, but I have requested the office to make the documents available.
Because you would appreciate that the bad buildings strategy and this operational plan are fairly central to the issues that this Commission is confronted with.
Completely agree, Chair.
Okay, again, I must leave it there in the absence of the documents at this stage. But can I then move to deal with the question of the waiting list that you referred to yesterday in your testimony? You referred to the general housing backlog since 1994 and the waiting list for the provision of RDP or other state housing. My understanding is that this waiting list is not publicly available as such.
The list is available. The last time I checked, I know that human settlement, both at the national, province, and local, work on that list to allocate housing across the country. So that list should be available through human settlement. So we could request for that list. Yeah.
Now, it's not in our possession, and perhaps we've misunderstood the position, but our understanding is that it's not actually a single list of 100,000 names, for example, but more a collection of various plans and lists and engagements involving different communities and parts of the city, rather than a single composite list. But perhaps you could assist in that regard.
As I say, the list is available, because if you look at the mega projects that we are developing is based on that list. But that list, of course, excludes the in-migration that we talk about, which is specific to Region F. So that will be an addition to that list in terms of backlog on human settlements.
So new people wouldn't appear on the new people who've moved into Region F wouldn't appear on that list?
No, they would not appear on that list.
And when we talk about new people, what period are we talking about?
Well, we could actually talk from about the time that I joined the city, to about 2010. I think we started having major challenges in relation to bad buildings, particularly in Region F. I think that's the time that I really became, or it became a major problem for the city.
So if I put it to you that some of the residents of the inner city are likely to be on the list, what would your comment be?
I generally wouldn't be surprised, Chair, because there are those that move from Soweto or from Orange Farm and move into the inner city for different reasons. So it's likely that they would have applied for an RDP house and they've not received it, and of course will not remain in those conditions or in those settlements would move into the inner city. So it wouldn't be a different shock to the system, as it were.
In your testimony, you gave a figure yesterday of around 100,000, an estimate.
101.
I beg your pardon?
101.
101,000, yes. Chair is holding me to more accurate standards. You gave an estimate of 101,000 people. Is that your estimate of the backlog for housing, or is it the people who appear on the list, or perhaps both?
It's a backlog on housing. It's an official it's an estimate from the backlog on the housing. It's not necessarily the people who would have registered, but
Yes.
it's the number of units or properties that are required to at least deal with the backlog that is created.
It's an estimate of need.
Correct.
And would that estimate include or exclude the residents of the inner city?
It excludes it will exclude the residents of the inner city. Yeah. As I say, of course, you may find one or two people may pop up in the 1994 list, but it does exclude that. So the point we were trying to make is to really just demonstrate the pressure and the need for human settlements, not just in the typical RDP areas, but also in the inner city, and what puts the city under more pressure within Region F in particular.
Yes, yes. Now, ICHIP, when it was developed, contained an estimate of what it called households at risk in the inner city, households in need of housing in the inner city, and that was an estimate of 30,000 households at that point. Do you have a comment on that estimate? Do you agree with it, differ with it?
No, Chair, I wouldn't necessarily differ with it, but I just think from that time to now, that request would have increased exponentially if you look at in-migration, both from the rurals and then from other African countries, which also adds a bit of pressure. So I think those households would have increased by now. In fact, the evidence on the ground is that there has been an increase in those households.
So you've given the estimate of 101,000 people in need of housing, representing the backlog outside Region F, and you accept that the need in the inner city would be at least the 30,000 households. It may have increased beyond that. Do I understand you correctly?
That's correct, Chair.
And those would all be people who are in desperate need. There may be different degrees of desperation and need, but those are all people in serious need of appropriate housing.
Agreed.
I want to bring you then to an issue that you addressed in your statement, and if I could take you back to it, this should be at page 41 of the blue file, and paragraph 12.3. Do you have it?
Yes.
In paragraph 12, you identified a set of difficulties in enforcing the applicable bylaws to inspect the premises, identify health and safety hazards, and attend to the necessary evictions to either decommission or reconstruct the building, thereby potentially mitigating this tragic fire, the fire at Usindiso. And then you said that these challenges include, or that these difficulties include 3 subparagraphs. And you talked to all of them yesterday: legal impediments, lack of financial capacity. It's the third that I'd like to take you to, where you refer to the moral hazard of prioritizing the provision of housing to people who have illegally occupied, abandoned, or derelict buildings. And we've already covered this ground to some extent, that there's a significant proportion of the population who are technically unlawful occupiers under the PI Act and who are living in the inner city. And in your testimony yesterday, you sought to clarify what you meant by the moral hazard here. And you suggested that it's a concern about prioritizing those new occupiers over people who've been on the waiting list. Did I understand you correctly?
That's correct, Chair.
Now, I want to put to you that what your statement conveyed, at least to us, is that there's a moral objection on the part of the city to providing housing to people in the occupied buildings in the inner city. And I want to put it to you that that moral objection would be inconsistent with the city's constitutional obligations that we dealt with at the beginning, and indeed inconsistent with much of what you've said about the city's policy positions. And that the constitutional obligations and the city's policies actually require the city to prioritize this group of people. Do you have any comment in that regard?
I do, Chair. Firstly, I would completely disagree with the proposition that has been put on the simple basis that we are simply demonstrating a challenge that is either created by the constitutional obligation of the city to provide housing to the 101 list that we already have, but also in the list of priorities and given the competing needs of the city, how do we also balance providing the same services to the occupants in Region F? But we also object to that on the basis that if you look at the bed building strategy, and what we've demonstrated to do was that we can't use the same approach that we use in the periphery by building RDPs in the inner city, because it's not possible. Practically, it's not possible. So we do need to use the resource that we have in Region F to provide affordable housing, whether through the state or the private sector. So this was simply a demonstration of the moral dilemma that we probably have, but it doesn't simply mean that we put the dilemma and we walk away. We demonstrated that we are looking at different strategies. In fact, we've implemented different strategies to also accommodate the people who are in Region F, who are in bed buildings, because they are not there because of their own volition. It's the economic and social conditions that puts them there, and we can't ignore that fact. So we spoke about the corridors of freedom being developed by the city to look at not settling people in the periphery, but in the inner city where they work, live, and play. So it's really a demonstration, but it's not the fact that we have a moral objection to looking after the occupiers or in the Region F. But it's simply a point we're emphasizing, and to drive us to look at, to think a bit outside of the box when we look at Region F, as opposed to providing RGPs, which is, of course, a program of government. We do need to look at a different approach when it comes to Region F in particular.
Thank you, Mr. Makola. That clarifies things somewhat. So the residents of the large buildings in Region F would, in fact, be a priority for the city?
Yes, they are a priority, including all other citizens and residents in all the 7 regions of the city of Johannesburg. It's a matter of finding different solutions for the different regions, because the profiles in the different regions are different, and therefore the solutions would have to be different. I don't think it's a matter of prioritizing one or the other. We were simply just saying you have these 2 different needs from 2 different groups, and that require, but at the end of it, they all require a sustainable human settlement, and how you deal with that is what's important.
Thank you, Mr. Makola. Your explanations now have clarified things significantly. I do want to put it to you that what you said in your written statement is somewhat at odds with what you've now explained. And I want to invite you respectfully to consider withdrawing your statement in paragraph 12.3 that there's a moral hazard of prioritizing the provision of housing to people who have illegally occupied, abandoned or derelict buildings. With the benefit of this exchange, would you have phrased that differently at this point?
Probably, Chair, we could have found a better way to demonstrate the point, but again, as I say, it was really just to demonstrate the challenge that you have from a moral base, and nothing malicious or nothing against the occupiers of the illegal building, because at the end of the day, we do need to find a solution for them, and a livable solution, which is part and parcel of the city strategy anyway. So I suppose I should accept that we should find a different way to demonstrate or make the point.
Thank you, Mr. Makula. I appreciate that. I'm going to move to a different topic now, and it's the issue of ICHIP, which you've also mentioned on a few occasions already. The city invested significant resources in the development of ICHIP. Isn't that so?
That's correct, Chair.
And city officials were heavily involved in the development of ICHIP.
That's correct, Chair.
This included the involvement of city officials in the costing of the programs proposed in ICHIP.
That's correct.
And in fact, recall, I'm not sure if you followed her testimony, but Dr. Tanya Zak, when she testified, described this, having been involved in many similar processes of policy development, as the best such process she'd ever been involved in with the city. She was very complimentary about the process. Would you share that assessment?
Chair, I'm reliably informed that I didn't follow the testimony, but through the briefing sessions, I have been briefed that is her testimony. Yeah.
And the evidence is that ICHIP was then approved by the mayoral committee. That's correct, is it not?
That's correct, Chair.
But as we understand it, ICHIP was then not ultimately tabled before council for final approval. It was not considered by council. What's your understanding?
Chair, I don't recall that it was ever sent to council for final approval or for noting, but I can recall that mayoral committee had supported the strategy completely entirely. Mm-hmm. But of course, having not been in the accounting officer at the time, I would not have reasons as to why it never got to council and why it must go to council, because you must be clear whether you want council to note or you want council to implement, to approve the strategy, as it were.
And can you assist us there in your understanding? Was council approval necessary, or would noting have sufficed?
Noting would have sufficed for council, because you are not developing a policy, as I said, which is the responsibility of council. You are merely developing a strategy or a plan that must be implemented via the administration and oversighted by the political executive and oversighted by council.
Okay, thank you, Mr. Makula. We'll take up these issues further with Mr. Nkoane, who discusses it in a little bit more detail in his statement. But what he does indicate is that various parts of ICHIP, the different constituent programs, are being implemented by the city, certain parts of it. Is that your understanding too?
That's correct, Chair, because as I indicated during my evidence was that what ICHIP was essentially talking about was providing social housing or affordable housing within the inner city, which is Region F, which we completely agree with, because in order to resolve the issues of bad buildings, but in the main to make sure that people settle in proper formal areas, we do need to provide that. I guess what we are now accelerating is it done by the state, or is it done by the state and the private sector? And how do we then use the current legislation and policies in the city to make that a reality in the inner city? And that's what we are obviously doing now in terms of going to council, putting it to the private sector. As I say, around 2016, 2017, we attempted to release certain buildings, but we didn't put conditions. So we'd simply say, if you're a private investor, you can buy the building and basically reconstruct it into whatever you want it. But this time we want to be deliberate that if you are going to do a mixed use, as an example, it must contain affordable housing, commercial, office block, and so that we have a 360 solution to that.
Mm-hmm. Mr. Makwala, on the issue of state provision and the involvement of the private sector. ICHIP, of course, recommended a combination, or proposed a combination of state provision, private sector provision, including subsidies. As a general approach, that appears to be the approach that you also support.
That's correct.
And in developing the bad building strategy, let me put it to you this way. How do you see the relationship between the bad building strategy and ICHIP? Do you consider them to be consistent with each other? Are there areas of similarity and difference? How should we consider the two together?
Chair, I do believe that they complement one another. In fact, the ICHIP would have done bulk of the research that would have had to start to do in the development of the strategy. Hence, we had to go back and look at what instruments are already available within human settlements as a stakeholder. And again, as I say, what we had not emphasized on when we released the properties to the market was to be specific that when we release that piece of land, we will only approve through development planning if it's a mixed use that also includes social housing or affordable housing from the property developer, as opposed to releasing it like I can use the Bank City as an example, where bulk of it is office space and did not make accommodation for any residential. I think Maboneng, we've achieved slightly that because we do have a mixed use in Maboneng, and therefore you see how Maboneng has then redeveloped into what it is today. And we do want to replicate the same approach in the rest of the other precincts in the inner city.
Thank you, Mr. Makola. So just to understand you, the bad building strategy didn't involve the same extensive research process that ICHIP enjoyed. It's more action-focused. Would that be fair? But please explain in your own words.
That's correct, Chair. I think I did indicate that the bad building strategy is not, we did not reinvent the wheel. We've looked at what is already on the ground and how do we enhance that to move towards implementation. Because I think there's a general view that government has a lot of policies that are good and positive, but the issue is in the implementation. So what we really wanted to do was not spend a lot of time on the research because it's already been done. The evidence is there. We know what the challenge is. What we now need to make sure is that we focus on resolving the problem holistically and then move towards the implementation, which is why we took the decision that once we accepted and agree as administrative, even though we must take it to the other committees for noting, we should still proceed with the implementation because, as I say, it's in the implementation that you then get to actually find whether the strategy is aligned or not and then readjust and realign. But the high-level strategy is exactly what it is. Take what is already available and run with the implementation.
So you would accept that ICHIP as a general program of action remains viable and appropriate?
That's correct.
And that was the evidence of our experts. Would you accept too that it's the costing of the programs in ICHIP, subject to updating, some years have passed, is a viable starting point for costing?
Yeah, Chair, I wouldn't really want to say it would be a viable because I think conditions would have changed from the time that it has been approved. But I suppose it's something that you really need to look at. But again, I want to make the point that I made earlier, that there's a difference between conceptualizing the plan and doing the research. Because once you start doing the implementation, you actually realize the other challenges that may arise or other impediments that you may then have to sort of deal with. Right?
Yeah.
As an example, at the time, if we go back to, you were dealing with 30,000 occupants. At this point, you are dealing with more than that. But also, if you look at the prevalence of bad buildings, as it were, has increased from what it was then to what it is now, and the conditions are different. So you may want to go back and revisit the financial model in line with, of course, dealing with the housing backlog.
Thank you, Mr. Makola. Perhaps I should have been more specific. There are perhaps two things that I want to put to you. The one is that that costing, subject to the sort of updating you're describing, would be a reasonably accurate starting point. And the second thing is affordability. So if I can deal with the first one, you would accept that it would be reasonably accurate as a starting point, subject to updating.
I suppose as a starting point, yeah, we could work with that.
And then on affordability, I want to put it to you that that process of costing involved heavily the city's officials, and that it would be, again, a reasonable starting point in terms of affordability. We're not talking about a set of programs and figures that are out of all the realms of possibility for the city.
Look, I would have to be careful how I respond to that, because during that time and now, you'd also appreciate that the revenue base of the city has significantly changed. From collecting about 22 billion, we are now collecting about 17.4 billion in revenue across the property rates and the trading services. And that, of course, has affected the city's affordability in some of the programs. So you do have to look at that vis-a-vis the ability to collect. And I don't want to go into the reasons why that revenue base has been eroded, whether it's the economy, the change in the economy, whether it's the people's ability to afford to pay for services and that stuff. So you'd have to look at that cost vis-a-vis the city's financial position at this point and then try and reconcile the two.
Thank you, Mr. Makola. That we would accept that that's fair. If at the end of this commission, we were to, the proceedings of the commission, we were to propose that the commission recommend that ICHIP be updated by the city and placed before council, whether that's for noting or approval, what would your attitude be to such a proposal?
We would not have an objection to that. Of course, we would add that it will have to go through the planning committee, which also includes the financial aspect of it, but also look at the operational environment in the current space and probably do an adjustment or so. I don't think it's an objection to take that as part and parcel, probably as an annexure to the bed building strategy that we're already putting through that process and for council to note. We wouldn't have an objection to that, Chair.
Thank you, Mr. Makola. We will explore that in due course. I want to turn then to the topic of the budget, which you were commenting on a moment ago. And you have provided some assistance in this regard. But there are certain aspects of that of the budget position that remain unclear to us, and which we're hoping to clarify with you. And it may be that this needs to be done through the provision of a supplementary statement or particular documents that you might identify. But I'm going to begin to ask you the questions. And if you feel that the Commission would be better placed to have documents that answer the questions, please say so. The first question really is for you to guide us on what proportion of the city's budget relates to human settlements, to housing, currently.
Just clarity, so in excluding the national grants, or just because, okay, maybe if you agree, Chair, so the allocation of budget is based on three income streams. So it's the revenue collected through property rates, provision for trading services, water, electricity, and waste. And then there are grants that are at national and province, and then it's the equitable share. So as I had indicated yesterday, bulk of the budget from human settlement, because that mandate is that of national, implemented through province and local government. So bulk of the human settlement budget is from the grants, which is the USDG grant and the informal settlement upgrade grant. Then a small percentage is what we allocate through the collections in the city. Yes. So we may have to try and define that.
I'm more interested, Mr. Makola, at present in the expenditure rather than the sources.
No.
So in terms of the city's overall annual expenditure, or its annual budget and expenditure, what proportion of that goes towards human settlements, towards housing?
Chairs, again, you can't just answer that because if I look at what we've allocated now in the adjustment budget from the city's coffers, it's about 70 million And that 70 million does not go into the mega project, which is the big human settlements project. It goes into the refurbishment of old age homes, hostels. Even that is not sufficient. I do know that, Chair, the MMC was heavily complaining through the budget steering committee that you won't be able to achieve anything with 70 million capex that we could allocate to human settlements. And again, Chair, I think it's important to indicate that from an expenditure base on OPEX, human settlements does not implement majority of the project. So they obviously go through contractual obligations. They work with big developers. So the budget is really for the project managers and the salaries and that part. But bulk of it is done externally through capex. And that's why they'll have about 75% of the human settlement budget is capex. And then the rest is OPEX, salaries and contracted services and that part. But I suppose we can bring a document that so that the Commission has a full understanding and appreciation of the allocation that we can make available, Chair, either in the form of the full budget or the adjustment budget in the current financial year or even in the previous financial year.
Thank you, Mr. Makula, and I appreciate your efforts to be accurate and precise about the different aspects of the process and the costing. I'm going to ask you a similar clarification question. Again, it may require documents or for you to check data, but has the human settlements expenditure increased faster or slower than the average increase in the budget over the years? In other words, has the proportion of the city's expenditure on human settlements over the recent period increased or gone down?
It has increased, Chair, if you consider the mega projects that have increased. As an example, Southern Farms, Lufereng, Tanganani as an example. So you have about 4 or 5, and I'm sure Mr. Nkwana will talk to those in detail as additional mega projects that we've received. And I say, again, you have to understand it in the context that National provides the additional budget from a capital perspective.
Yes.
For the top structures. We will then provide the budget for the bulk infrastructure, which means the roads, the services, and some of the other budget doesn't generally reside in human settlements. We will allocate to JWEC Road Agency for the stormwater, for the roads to be developed in that area. So if you put together what Johannesburg Water, City Power, and JRA does, that budget obviously increased, but we don't allocate all of it to human settlements. And the portion that we even allocate to human settlements, they will also go and still appoint Johannesburg Road Agency as an agent, which is a state-owned entity, to do the implementation on their behalf, including City Power and Joburg Water, where there are bigger developments. So if you look at it in that way, you then realize that there's a bigger chunk that goes to human settlements, as it were, not the department, but the development of human settlements project.
Indirectly through other department expenditure.
Directly and indirectly, yeah.
Yes. One further question, Mr. Mr. Makula. You testified yesterday about the specific underspending in the 2021 to 2023 period, and you explained the two projects that were involved. I wanted to ask, to the extent that you're aware, what the history of under or overspending on housing is in the city, say, over the last 10 years.
I think we didn't have that problem. That's why I spoke about those two specific financial years, because I know I was involved in resolving the under expenditure. That was on the fact that the project planning was a bit problematic at that time in terms of the execution, because either the appointment of the implementing agent was done in the third quarter of the financial year, and that meant that you were unable to spend the entire amount. But what we then did is to request, because you can request for a rollover of those funds if you can demonstrate that the project has already started, and that's what we did. We requested National Treasury to do rollover with National Human Settlements.
But it was refused.
Some of it was approved, some of it was not approved. In specific projects where the project planning was still behind and the appointment had not been done, those were refused. Of course, those are the amounts that they refer to. Secondly, is we then, National Treasury also introduced the project preparation grant, which was then introduced, is ring-fenced in the office of the city manager. What it does is it allows us and the entities to then prepare the project in the year before we actually break ground. And that obviously has helped us to improve the expenditure in terms of human settlement grant. But we're not only looking at the human settlement grant. I was talking also about the public transport grant that we also received that was also under the same threat. And we looked at that challenge holistically.
Mr. Makula, I think your evidence on those issues was clear and we understood it. We may then explore some further questions around the budget data beyond what you've provided, but if we do so, we'll do so appropriately through correspondence, and we appreciate your willingness to assist where you can. We know that you have a demanding role. I'm going to move now to a new topic, and that's the issue of the ESP. This is dealt with at paragraphs 62 and 63 of your statement. Which is at page 51 to 52. And you testified about the ESP yesterday. You testified that residents of inner city buildings that are a commercial facility will not qualify, and that, as you say in paragraph 62, I beg your pardon, 63, most of the occupants of bad and hijacked buildings are currently not registered. And Mr. Nkwane says similar things in his statement, and deal with it with him in due course. You also testified that this issue of the ESP and access to it is now under review, as I understood your testimony.
That's correct. Yeah?
I want to deal first with the question of the application of the ESP. And to do so, I must take you, please, to the SERI Policy and Legislation Bundle, File 1. It should be one of the files in front of you, and it should say Policy and File 1.
File 3. No, this one.
And if I can take you then to page 543.1.
Yes, sir.
Do you have it, Mr. Makwala? It's headed City Services Expanded Social Package.
Yes.
And what you will see, Mr. Makwala, is that...
Give me the page number again, Mr. Brickhill.
I beg your pardon, Chair. It's 543.1.
543.
It was an insertion into the bundle. 543.1, and then the further pages go 0.2, 0.3.
Yes.
And Mr. Makula, what you'll see here is that there is an initial summary of the ESP policy on the first 4 pages, and then from 543.5, the full text of the expanded social package policy dated 2021. You see that?
Yes.
Okay. If I can take you then initially to page 543.15. This follows a series of definitions.
Yes.
Perhaps we can start at 543.14. It's the introduction, section 3.
Yes.
And you'll see references there to the Constitution, and the ESP is effectively the city's policy to give effect to rights in the Constitution to which it relates. And then if I take you to 543.15, paragraph 3.1 at the top of the page, the ESP reads in the first sentence, the ESP program is a basket of benefits and services which the city allocates to individuals and the households in which they live based on their level of poverty and vulnerability. You see that?
Yes.
And then if I can take you to the third paragraph on the same page, there's a reference to the previous ESP program was directly linked to account holders that qualify for ESP. You see that?
Yes.
And then if we move to the third sentence on line 3, the third line of that paragraph, it continues, however, households who lived in informal settlements and receive communal essential services are not on the databases because they do not have account numbers for individual FBS. FBS is free basic services. And it continues, sharing communal facilities therefore makes it difficult for qualifying households to access programs. Therefore, poor households in informal settlements were often rendered invisible. It is these poor households that need to make their way to the COJ's database for the provision of the ESP program through this policy. And then it continues, in the past it was assumed that one account holder unit equals one household, and policy formulation and planning was undertaken on that basis. This is often not the case, and there can be more than one household living on one account holder's unit. I'm just asking you to note what we've read at this stage. If I can take you then over the page to 543.16, again, the third paragraph beginning the ESP program thus, and it reads, the ESP program thus enjoys priority and is aimed at ensuring that poor and vulnerable households gain access to the package, maintain access to the package, targeting the poor and targeting non-account holders. Maybe that's an appropriate point at which to pause, and I just want to put it to you that the purpose of the ESP as articulated in paragraph 3 is to provide services to poor individuals and the households in which they live. You'd agree with that?
Agree, Chair.
And that there was a recognition of that it was a problem in the previous version of the ESP, that the ESP was linked to account holders and an emphasis on reaching non-account holders where they are poor individuals and households.
That's correct, Chair.
Thank you, Mr. Makula. If I can then take you to page 543.19. Which is headed 4.5, Scope and Application of Policy. And again, I just want to identify that first sentence. The policy is aimed at providing multi-pronged assistance to poor and vulnerable residents and households based in the City of Johannesburg jurisdiction. So the target of the policy is poor and vulnerable residents and households, correct?
That's correct, yes.
If I can then take you to the specific qualifying criteria which are set out at the foot of that page in paragraph 4.5.3. The paragraph under the heading there reads, the criteria for admission to the ESP program will be based on individual vulnerability score and on the weighted average of income and individual vulnerability attributes, such as those mentioned in section 4.5.2. So the ESP sets up a system based on an individual vulnerability score, which takes into account income and other aspects of vulnerability. Am I correct?
That's correct, yes.
And then if I take you to 543.20, so just over the page, top of the page, the ESP reads, the criteria will take into consideration vulnerable individuals, as stated under section 4.5.2, and the following, and there are 3 bullet points, must be a South African citizen or a permanent resident, must reside within the City of Johannesburg boundaries, and then the third bullet refers to applications where a household or any member in the household owns more than one property will be disqualified. I think we're not particularly interested in those at the moment. What follows is a table to calculate vulnerability. Do you see that, table 1?
Yes.
And the first row there sets out income bands. There are 4 income bands: less than 1,100, 1,100 to 4,200, 4,201 to 6,300, and then 6,301 to 10,000 rand. Do you see that?
Yes.
So there are 4 income bands. The lowest one is people earning below 1,100 rand per month, correct?
Yes.
And the highest band is the 6,301 to 10,000 rand band. Sorry, you
That's
need to
correct,
respond
yes.
audibly, please. Thank you. So the upper limit to qualify for the ESP is 10,000 rand income.
That's correct, yes.
And if we go just over the page, I'm not sure if your version is in color or black and white, but the 4 bands are set out on the middle of that page. Bands 4, 3, 2, and 1, which are based on those income bands as well as scoring for other vulnerability criteria, such as women, senior citizen, disabilities, and so on. Do you see that?
Yes.
Okay, I've had to take you through some detail, but I want to pause to identify what this means. You testified yesterday during your examination in chief that in your view, informal settlement residents in the City of Johannesburg would generally qualify for the ESP. Maybe saying they would all qualify would be putting it too high, but that you would expect that they would generally qualify, residents of informal settlements.
That's correct, yeah.
And I want to put it to you that the residents of the inner city buildings that this commission is concerned with, that are unlawfully occupied, and the TEAs, would similarly generally qualify within those bands.
Agreed, yeah.
And more specifically, I want to put it to you that most such residents of the inner city, in the buildings we're concerned with, would fall in the first 2 income bands, less than 1,100 or 1,101 to 4,200. Would you accept that?
We'll accept that, yeah.
Okay, if I can take you then over the page to 543.22. Again, yours is less colorful than mine, but the content is the same. There are 4 arrows and tables for the 4 bands, and basically what one gets if one is in one of these bands of vulnerability. With band 4, the top one being the highest vulnerability, so the most vulnerable people. And in the text box, we're told that those who qualify within band 4 will receive water subsidy, conventional water cap per household per month, 15 kiloliters per household with at least 50% qualifying individuals, electricity subsidy, prepaid conventional electricity cap per household per month, 150 kilowatts for households, a rate subsidy of 100%, sewerage and refuse 100%, and other services as determined by the annual action plan. Effectively, that most vulnerable category would receive an allocation of water, an allocation of electricity, 100% rate subsidy, and 100% sewerage and refuse subsidy. Am I correct?
That's correct, Chair.
And then as we go down the other bands, they receive something similar, but basically a little bit less. So in band 3, the water is only 12 kilolitres instead of 15 kilolitres. The rate subsidy is 70% instead of 100%. And those figures continue to drop as one goes into band 2, and band 1 provides less benefits. Is that correct?
That's correct, Chair.
So the purpose of the ESP is based on that individual vulnerability to grant people free or subsidized services and rates and sewerage and refuse subsidies to enable them to access those services. Is that correct?
Yes, that's correct.
And there's one aspect that perhaps we should just emphasize, which appears in the first text box that we looked at. It's the reference to 15 kilolitres per household with at least 50% qualifying individuals. So the approach of the ESP is that at least half of the household must qualify, must meet the requirements of the ESP, and then the household will receive, in this case, the 15 kilolitres of water. Is that correct?
That's correct, yes.
So, for example, that would apply to a household where there are two partners, and one partner is a South African or a permanent resident, and the other person is a foreign national. That would constitute 50% of the household if one of the members qualified. Is that correct?
That's correct, Chair.
So the approach of the ESP is not to say we'll look at every member of a household and every member must qualify, and only those who qualify will be able to access the water or electricity. The approach is a more practical, sensible one. 50% of the household must qualify, and then the ESP benefits are provided. Is that correct?
That's correct.
If I can take you then to 543.29. We can move forward, please. No. 543.29. So the main heading in paragraph 7 is policy interventions and implementation, provision and procedures. And you've spoken in your evidence emphasizing the need to have concern for the practical implementation and not just the theory of different policies and programs. This is the section of the ESP that takes those issues seriously. And I want to draw your attention to the footer of the page, paragraph 7.1.1, under the heading Enhancing Access to ESP. Do you see it?
Yes.
And the ESP there provides, the DSD needs to ensure that access to the ESP is afforded to more people and communities who were previously excluded from gaining access to the program. Additional interventions to enhance access may include the following, and there are then subparagraphs A to G. I just want to draw your attention to two of them. First, subparagraph C, which refers to incorporate the unique needs of residents, tenants, and backyard dwellers throughout the city. And then if I can take you to paragraph F, regularly reviewing the documentation required in order to ensure that people living in informal settlements, back rooms, and those living in high-rise buildings are not excluded from the program. So I want to put it to you that the ESP on its own terms emphasizes the need to reach non-account holders in the provisions we've seen previously, to take into account the unique needs of residents, and particularly those living in high-rise buildings. Would you accept that?
We accept that, Chair.
So if I may then return to your evidence in this regard, and I appreciate that this evidence may have been based on advice or information you've received from others. But what I want to put to you is that there is no exclusion in the ESP of commercial facilities, which is the term that you used in your statement, indicated that people in the buildings that this commission is concerned with, where that building is a commercial facility, would not qualify for the ESP. I want to put it to you that the ESP, in fact, does not exclude such residents.
I wouldn't necessarily agree with that, Chair. I think the fact that the property is a commercial property limits the extension of the package to the occupants, because you would agree that part of the condition is that you have to be registered, you must produce a registered account in order for you to then benefit in the current policy. So, which means you have to produce an account, because if you look at the rebates we talk about, it's the rebates allocated to your property rates. If you look at the discounts, they refer to your water bill, they refer to your electricity bill and your waste bill, including sewer. So therefore, you have to be registered, a owner of an account, which means you must have a registered account in order for you to benefit. So in the case of these properties, the person who holds the account, because we don't issue accounts to the different units. We issue the account to the owner of the property and not the occupants.
Maybe to aid on that score, let me first put it to you, Mr. Makwela, that the term commercial facility doesn't appear anywhere in the ESP. Those words, that term doesn't appear anywhere. Do you accept that?
Of course, it doesn't appear in the policy.
So your concern is that there needs to be an account. We've dealt with certain provisions of the policy that already emphasize the need to reach non-account holders, but perhaps I can take you to 543.2. Which lists the more practical requirements, the documentation required. Are you there? 543.2.
Yes, I'm here.
And do you see about 2/3 of the way down the page the heading types of rebates you may qualify for?
Yes.
You see that heading?
Yes.
There are 2 bullet points under that. The first bullet point is property owners qualify for subsidy on their rates, refuse, sewer, water, and electricity services. And then the second bullet, non-property owners or non-account holders qualify for rebates on water and electricity services. So what I want to put to you is that under the ESP, a person who is not a property owner and not an account holder with the city nevertheless qualifies for rebates on water and electricity.
That's correct in relation to the revised policy, which is the document that you are referring to now. The current policy does not have these conditions. The current approved policy that we register ESP on is not based on this. This is a revision of the policy.
I'm sorry, I don't understand that. Are you saying that there's a newer version?
So if you look at what we are referring to in the statement as the current qualifying criteria, or maybe let's go back to point number 2, where you referred me back to. If you go just up onto that, so if you go to the documentation required, there's a point that you must have the City of Johannesburg rates and tax account.
Yes.
Yeah.
Obviously, that would only apply to a property owner.
Correct. So it refers to the owner of the property producing the rates and tax account, because the rebate that you receive is based on the property that you have. So we remember, rebates, how they work. I'm not sure if we have time to, but the rebates are based on the valuation of your property. In the valuation roll, we then make provision for rebates based on the value of the property. So if the property is above, let's say your property is 1.2 million, we'll give you 10 or 20% of rebates on that value. What it means is that when we issue you with an account, it will have minus that rebate that we provide on the property value. As an example, on the resident side, we charge you about 0.98% of the property value. From commercial, we charge you 2% for property rates and taxes, 2% of the property value. Then we exempt some of those properties, exclude that. So you have to then understand it in that context, that you have to look at all of that. That is why we require the rates and taxes. So part of the review of the policy that I spoke about, which is what the document that you are looking at, but its limitations currently is that it doesn't consider the allocation that National Treasury makes on the equitable share, because the equitable share allocation from National Treasury on the budget talks precisely to the people who are indigent. Now, when you go to the city's current database, you'll find that you only have about 18,000 people registered. Take that 18,000 vis-a-vis the 5.8 population that you have in the city. Of course, you can see that there's a mismatch in the number. And the reason why you have the mismatch in the number is the current conditions in the policy for you to register indigent population onto the ESP. And that's a point we are making in the submission, that the current policy has a lot of limitations and impediments to us registering more people onto the ESP. And I agree with you that all the sections you've taken me through, we agree that more people should be benefiting from ESP. However, for you to benefit, you must be on the ESP register. Hence, we had said, review the system, how we put people on ESP, create a separate system that aligns with National Treasury, that aligns with the poverty index, because even if you use the vulnerability scale, it does not give you the poverty levels of the individuals, but it gives you that of the households. As an example, I did say, Chair, we're already providing 6 kiloliters of water to all residents in the city, whether they can afford or not afford. And there's a debate now whether that is financially viable for Joburg Water, an example, as an entity, because it means even people who can afford are then getting 6 kiloliters of water, when in fact we could be preserving only that to those that can afford. So I think the point we are making here is we do need to make the system to be robust to accommodate more people, this including the occupants in Region F, because the current policy does not allow that, and the current system that we are using does not allow for more people to benefit. As I say, that is statistical. We can produce that evidence. I do performance review for the social development. On their register, they only have about 18,000 people. So if you look at that at face value, you would agree that that number is incorrect if you look at the number of indigent population in the city, across the city, based on poverty levels.
Thank you, Mr. Makola. There's much with which we agree in what you've just said. It was quite a detailed response in terms of a larger number of people should be registered, that the policy commits itself to getting those people the services that it promises. Where we part ways, Mr. Makola, is that on its terms, there is no requirement to be an account holder. There's no requirement of zoning or the commercial nature of the building excluding anyone. And in fact, non-account holders expressly qualify for the water and electricity services under the ESP. I think that's the heart of the issue. It may be that administratively those people are not being assisted and not getting access. But in terms of the policy as it reads, we would put to you that the residents of such buildings, including what you describe as commercial facilities, do qualify for the services.
See, I don't think we are disagreeing on that proposition. The challenge is getting more people onto the external social package, which currently the system excludes majority of the people, not just in Region F, but across the city. And that, I think, is the biggest challenge that we need to sort of move beyond, because you also can't ignore on 5.3.2 these conditions and the documents that are required, because it's very explicit that you must produce all of these documents. So there is no provision that says you can exclude an identity document, for an example. It doesn't say you can exclude proof of residence. It doesn't say you can exclude rates and taxes. It says to you, for you to be registered on the ESP, you must have all of these documents submitted. And we are arguing that some of the indigent people or some of the people who can't afford do not have the rates and taxes with the city. as an example. That's why the argument about if you go to the informal settlement, nobody has a title deed in the informal settlement. We are not metering the trading services in the informal settlement. But does that mean they do not get free services? They receive free services. We provide water, we provide electricity in the informal settlement. And the question is, how do you then account for that water? Or do we exclude them in that space? So the point we are making in the statement, or at least the point I'm making in the statement, is that we do need to find a different way to account for residents who are in a commercial building, because for all intents and purposes, that building is registered on the city's account as a commercial property. And we do meter it or provide rates and taxes based on it being a commercial property and not a residential property. Yes, it's a residential property for the occupants, but it's registered as a business on behalf of the owner of the company or the property, who then is supposed to be getting rental from the occupants. And I think that's the sort of misunderstanding that we may be. But we agree with you that indeed the policy has to make provision for all people to benefit. But reality is you only have 18,000 people registered on the ESP, and that means it makes it difficult for the city to extend the same services to the occupants. And the point we make is the impediment now is on the basis of that particular property is registered as a commercial property as opposed to a residential property in the name of the occupier, or at least the unit, because none of the units are registered to the occupier. They are all registered to one individual who is the owner of the building. And of course, we've had a discussion about the ownership of the property and what then happens beyond that.
Chair, I see that it's 1 o'clock. It may be a suitable
Yes.
time to take the lunch
Yes.
adjournment. Thank you,
How
Mr.
long
Makula.
are you going to be, Mr. Bricky?
Chair, I envisage not being longer than another 20 minutes.
Another 20 minutes. We'll take a lunch adjournment and reconvene at 2 o'clock. Mr. Bricky?
Chairperson, Commissioner. Chairperson, just to indicate that during the lunch adjournment, our colleagues from MNS were able to locate the bad buildings strategy, Annexure ON5 to Mr. Nkwane's statement.
Yes.
They have not yet been able to procure hard copies for yourselves and for all of the parties. But at this stage, I feel comfortable concluding with the witness.
Okay.
I will ask a couple of high-level questions about the document, but it's our sense that we can do that without the document being before everyone at this stage. Mr. Makula, thank you. We're drawing towards the close. We were dealing before the break, thank you, with the issue of the ESP. And I had put it to you that on the terms of the ESP, residents of inner city buildings would generally qualify, regardless of the nature of the building, given that the policy is targeted at non-account holders, is based on vulnerability of the individual and the household. You were seeking to explain to me that there are difficulties of some sort with registering those people. And I wanted to just pick up there. To be very clear, our case is that in terms of the ESP, those residents of inner city buildings qualify for the benefits in terms of the ESP. It's a separate question whether they apply, whether they get them in practice. But in terms of the policy, they qualify. Do you have anything further to add or to respond in clarifying your position there?
No, I have nothing further to add.
Okay. Let's move then to what has actually been happening, because the second claim that you made in your statement is that most of the residents of the so-called bad buildings are not registered under the ESP. Now, SERI and the ICF previously gave evidence in this regard in the form of Mr. Mahlangu's main statement. And I want to just put to you what he said there. It's not necessary at this stage to take you to the statement because there are just some discrete averments that he made that I'll put to you. But it's not necessary to take you to the document at this stage. For reference purposes, this is Mr. Mahlangu of the ICF's main statement, and at page 894, paragraph 240, you don't have the file, Mr. Makula, but in the interests of time, I don't think you need it. If you say you do, we'll locate it. This is what Mr. Mahlangu says. Most of the buildings in which the ICF organizes lack access to basic services, including electricity, potable water, basic sanitation, and waste removal, and carry debts of millions of rands for non-payment of services and rates. In addition, although the residents of the building qualify for the provision of free or at least subsidized services in terms of the city's own policies, in particular the expanded social package, ESP, the city and its entities have failed to provide them with services. And Mr. Mahlangu continues at page 897, paragraph 252, where he says, the occupiers of the above-mentioned buildings, having discussed buildings in which the ICF organizes, qualify for and ought to benefit from the ESP, which was introduced to provide qualifying citizens in the city access to free basic services. He attaches a copy of the ESP to his statement, and he says, despite this, the city has largely refused to engage with the occupiers regarding provision of basic services, including free basic services. And then finally, Mr. Makula, at page 900, paragraph 262.2, Mr. Mahlangu said the following: the city's failure to provide free basic services in terms of its own ESP and related policies, and the disconnection of basic services in occupied buildings, result in the buildings becoming derelict and without access to basic services, resulting in the occupiers turning to illicit connections and relying on water from firefighting installations. So this was obviously before you gave your evidence. It was Mr. Mahlangu's main statement from last year. And there Mr. Mahlangu makes a number of claims. The first is the proposition that I've put to you, that the residents of the inner city buildings in which the ICF organizes qualify in terms of the ESP for basic services. That's the first proposition. The second is that generally they're not receiving them. And the third is that the impact of this is that the buildings deteriorate and that people resort to illicit connections using water from firefighting installations and so on. I'll give you an opportunity to comment on any of those propositions you wish to now, but that was Mr. Mahlangu's earlier evidence. Do you have any comment in relation to any parts of that?
Chair, I do have comments, Chair, and I do want to start with the proposition that you are putting, that the reason why these buildings become derelict and there's illegal connections is because the occupants are not benefiting on the extended social package, and would disagree with that. Because the building become derelict because the owner of the property has abandoned the building for one reason or the other, and is unable to maintain and keep the building in the required standard in line with the bylaws, and therefore is unable to reinvest the money that he would have generated through the payment of rent to reinvest in the infrastructure of the property. So it's not correct that the building becomes derelict and the occupants resort to illegal connection to either use water or electricity. It's an illegal act that moves into that space, and it's not the occupants because they don't get extended social package. Two, Chair, is that if you go back to the same document that you referred me to, under 543.2, and if you read that line, and I think you need to read it in context, because it says to types of rebates you may qualify for, you may, and I think we must underline the word may. It doesn't generally say you will qualify, because there are conditions that you will find in the first instance of the same document that gives you the qualifying criteria, and then gives you the documents that you must submit in order for you to qualify. And I think that's important to sort of re-emphasize, and the documents are listed. Property owners qualify for subsidy, and I think we've read through that. So it is not automatic that because your level of poverty or your vulnerability is at a particular level, you automatically qualify. It simply says you may. Lastly, Chair, is that the point we are making in the statement is that, first and foremost, the property that you are living in at the moment is not your property. It is owned by a particular individual. And that individual uses that property for commercial purposes, which means they generate revenues from the rental that people pay. And that, if you look at the documentation required and the qualification criteria, you look at them together, becomes an impediment for the occupants to directly benefit from ESP. Now, what we are simply saying here is that in order to expand, and we do not want to include the occupants of any property that is either a bed or a high-tech building. Hence, we're looking at the system that we are currently using does not allow for the households in the bed buildings to qualify. And it's our position, Chair, that we are now saying let's review and revise that system and that process to ensure that all the people who are in those buildings qualify and we provide the services. Because again, Chair, I go back to, if you look at the type of rebates you get them in 3 areas. You get a rebate on the property rate. You get a rebate or a discount on your electricity account, whether prepaid or postpaid. You get a discount on your water account. Now, if you look at the people in the buildings, they do not own the building, neither do they own the units that they live in. Therefore, they don't have a meter where we can gauge whether you get the discount on your electricity or your water meter, or even the removal of waste. So we agree with you that indeed we want to expand extended social package to everybody. And this is why we are saying move away from the vulnerability, not move away, add on to the vulnerability and look at the poverty levels of the people who are in those buildings and find a way to remove it away from the property being the contractual person that you contract with. In the absence of that, we are continuously going to have this debate, and the conditions are very clear in relation to what you must provide. The criteria does not say you must have one or two or the other. It says you must have all of these 7 documents for you to benefit from the ESP package. So it's not true that buildings are getting derelict and there's illegal connection because people can't access extended social package. I wouldn't agree with that. But where I agree with you is that we need to do more to make sure that more people benefit from the extended social package. And people in Region F must also benefit the same as everybody who's benefiting in all the different regions. Thanks, Chair.
Mr. Makola, I don't want to traverse this ground too many times, but I want to put it to you that there is no provision in the ESP that disqualifies residents of inner city buildings who are not owners or not account holders from benefiting from the ESP. To the contrary, they expressly qualify, and they're the group that are prioritized in terms of the ESP. Let me deal with the text that you draw attention to on 543.2. You refer to the heading types of rebates you may qualify for. The relevant bullet point is the second bullet point after that, which states non-property owners or non-account holders qualify for rebates on water and electricity services. Are you suggesting that the word may in the heading gives the city a free discretion to decide who it grants the ESP to or not?
So I think you are misunderstanding the point I'm making, and I'm going to try and re-emphasize the point. And I'm saying to you, if you go to the same document, for 543.2, there's qualifying criteria. It gives you 3 bullet points. After that, it says to you here that documentation required in line with the qualifying criteria. So in order for you to access whether point A or point B as a property owner or a non-property owner, you must provide the city with all of these bullets, 1, 2, 3, 4, 5, 6, 7. And once we've assessed whether you've given us all of these 7 items, then we can make a determination whether you qualify on point A or B under the types of rebates you may qualify for. So I'm not suggesting that this says you won't qualify. I'm simply saying for you to qualify, it's not a free entry. There's a pre-qualification process that you need to go to. And the point I make, Chair, is that you must satisfy the city with all of these 7 points, because it doesn't say you can skip 1, go to 3, skip 4, give a text, then you qualify. It says to you, give us all of these documents, because the process and the system is designed in such a way, because it's not like the rebate you get money or you get money paid into your account. The rebates are deducted from your account. As an example, if we give you 6 kiloliters of water, when we send you a statement, every month we give you a statement based on your consumption. We meter your services. Out of, let's say you consume 20 kiloliters as an example. Of the 20 kiloliters in the account that you've consumed, we will then take out 6 kiloliters because we agree that it's for free. We will then take out, let's say, 5 kilowatts of energy from your statement from your account. We will remove it. At the end, if that, let's say that 20 kiloliters of water equates to 250, based on the rate of a liter or kiloliter per minute or per hour. So at the end, instead of paying 2,000 for your account, total account, because there are 5 areas that you pay, We will then rebate all of those. You will then pay 500 as an example, because the 500 is a rebate on the property rate. The other 500 is a rebate on water and electricity. That's how you benefit from the social package. So when you do not have the instrumentation to measure the amount of water you use, now when you go to the commercial buildings, Chair, there's only 1 meter for one property. It's a bulk meter. We meter into the bulk. The owner of the property is the responsibility of the owner of the property to then redistribute that water inside the meter. And the only way to do it is to make sure each unit has a different meter to measure your consumption, both on water and electricity. Now, with property, it's different. With property, we look at the value of the property and we issue the rebate. So when you come to pay your account end of the month, we then remove that amount that is allocated to the social package. And that's how the social package works. Now, the system creates an impediment when it's a commercial building or a commercial property. And that's the point that we are making, Chair. But I think the biggest point is, what are we doing to ensure that more people benefit, which is what we also want as the city, for more people to benefit. And in particular, we want the people in Region F to benefit. And hence we are saying, let's revisit the system and the process that we are currently using for people to benefit on ESP. Because at the moment, we all agree that it does impede and it doesn't allow us to extend this beyond what we can at the moment.
Thank you, Mr. Makola. Let's move on from, we've put our position to you. Our position is that in law, those residents do qualify and are entitled to the ESP, and you've given your response. I now want to deal with what has been happening. And we provided this morning a supplementary affidavit of Mr. Mahlangu, bearing today's date. You should have a copy of that in front of you.
I can close this file.
You can close that file. It's this document, supplementary affidavit of Siyabonga Mahlangu,
I'm on
on behalf of the Inner City Federation. Mr. Makola, Mr. Mahlangu, I've taken you through his initial evidence. This is a short supplementary affidavit. And I'll just take you through it briefly. Mr. Mahlangu identifies himself in paragraph 1. In paragraph 2, he confirms he deposed to the ICF's main statement that was delivered on 18 June 2024. That was the statement I was referring to earlier. He confirms that he testified on 27 and 29 November 2024. In paragraph 5, he records that as part of my ordinary duties as the Secretary General of the ICF, I have been personally and actively involved in all matters relating to the facts to which I depose in this affidavit. Some of the facts to which I positively swear in this affidavit are derived from the records of the ICF, which records are in my possession and under my control as the Secretary General. If we then move to paragraph 7, he refers to the City of Johannesburg's statements that have been delivered, including your statement and Mr. Nkwane's statement. In paragraph 8, he notes the allegations that you and Mr. Nkwane make regarding the ESP to the effect that occupiers do not register. So not that they do not qualify, that they do not register for the city's ESP. And in paragraph 9, the purpose of this supplementary affidavit is to respond to your and Mr. Nkwane's allegations and to demonstrate that a significant proportion of occupiers have registered under the city's ESP, but have not been provided with the services by the city despite their registration. And he explains that in the remainder of this affidavit, he deals with the occupiers' registration under the ESP, the evidence thereof, and the role of the ICF in assisting the occupiers to apply for assistance under the city's ESP. From paragraphs 11 to 12, he refers to his main statement and those paragraphs that I've already taken you to in terms of occupiers qualifying and that they generally don't receive assistance and the impact that this has on buildings and illegal connections. We've dealt with those aspects already. In paragraph 13, he quotes the paragraphs of your statement, 62 and 63, that deal with the ESP on this issue. And then this is really the nub of it. In paragraph 15, he records your statement, Mr. Nkwane's similar statement, that the difficulty is that more often than not, the inner city residents do not come forward to take advantage of the ESP. Mr. Mahlangu then continues at paragraph 16 to say that as part of my ordinary duties as the Secretary General of the ICF, I have been personally involved in assisting the occupiers of various buildings to apply for the ESP, including the following buildings. And he lists 7 buildings: Sopa Road, Lalanati, 133 Albert Road, Wellport Motors, Mayfair, Drislington, and Manhattan Court. These are buildings on which evidence has previously been given in these proceedings. He then, in paragraph 17, records that having regard to current ICF records, at least 371 occupiers have registered for subsidized services under the city's ESP. That's 371 occupiers from those 7 buildings. He says that to avoid burdening the record, I will not attach each occupier's proof of registration form. Instead, by way of example, he attaches one registration form of an occupier from each of the 7 buildings. He then continues that the remainder of the proof of registration forms will be made available to the Commission during the hearing of your evidence if necessary. And I can confirm that we have the file of the 371 registration forms from occupiers of those 7 buildings. Mr. Mahlangu then draws the following observations at paragraph 18. It is evident from the above that a significant proportion of occupiers in the occupied buildings have registered with the city under the ESP, and that the city has processed and is aware of these registrations. The ICF also assists occupiers with applying for the renewal of their registration every 6 months in accordance with the ESP. Despite their registration, none of the registered occupiers have been provided with basic services by the city. And he concludes that he trusts that the above information will be useful to the Commission and confirms that he's available, if necessary, to give oral evidence on the contents of this statement, and that the ICF remains available to provide such other assistance as the Commission may require. So Mr. Mahlangu, Mr. Makula, long day. Mr. Makula, Mr. Mahlangu's evidence is that the ICF has assisted 371 occupiers from these 7 buildings in the inner city to register. And despite that, those buildings, those residents have not received the benefits of the ESP. So I first want to put to you that your and Mr. Nkwane's claim that occupiers generally don't register is not accurate, and give you an opportunity to reconsider that claim in the light of this evidence.
Yeah, Chair, I think we do need to go back to my statement, page 52, 63, because there we are quite clear that we are saying most of the occupants. We did not say all occupants don't register, but most don't. And if you look at the number in this affidavit, 371, vis-a-vis the actual amount of people who are in these buildings, you then realize that it's not the full population of the people who occupy these buildings in the inner city. But I don't think that is the crux of the challenge. Now, if you go to the same statement, you go to the Sopa Road 1, and you go through all of these documents submitted, you'll then realize that if you go further on that document, you would realize that there's certain information that is required. Account registration, what is your COJ municipal account? There's no information. What is your Johannesburg water account? There's no information. What is your pick it up account? There's no information. ESCOM, if it's ESCOM, and SUA an account. Now there's a reason why that information is there. Because if you understand how the social package benefits works, is that you must have all of these accounts for you to benefit, because that's how the city provides you with the benefit. Yes, you are registered, you are on the ESP, you have the ESP number, but you are not benefiting. You we are not getting the system because the process and the documents required are not complete. But over and above that, Chair, this is a commercial facility that is registered to a single owner that is not being subdivided to the occupants. So the occupants are paying rent to the owner or whoever they are paying rent to. Therefore, that is an impediment to the city providing these benefits. Because again, as I said, Chair, the benefits can only be provided to you if you have a working meter and we are able to meter your account, and then we give you a discount on your electricity account or water account or your rates and property. And that is the challenge that we're currently having in providing. So you can register, but you will not benefit because of the challenge you've identified. But Chair, I think we've even said we've gone beyond to look at how else can we make this even more better so that more people can benefit from the extended social package without necessarily including all of these requirements. And that's the work that we are doing now. But the policy, as it says, requires all of these documents. Hence, if you look at this form, all of them, if you go down, you'll see there's 0% on the benefit if you go further. Allocated benefits include the 0 for rates, 0 for sewer, 0 for refuse removal. And that's simply because if you go one up, you'd see that there's no city power account because this has to be added onto the city power account or any of the utilities account. So you may register, yes. And that's why in the statement we did not say everybody, we said most. Thanks, Chair.
Mr. Makula, would you accept then that the ESP is not currently reaching a large proportion of the most vulnerable residents of the inner city that it is designed to reach?
We agree, Chair, and we raised it in our statement. Even in my evidence, I did indicate that the reason why we are looking at alternative ways is because the current ESP does not extend to a lot of people that we want, irrespective of the inner city, but across the city of Johannesburg. And I make the example about we have 5.8 million people in the city of Joburg. You only have 18,000 people registered on the ESP. It doesn't make mathematical sense or statistical sense that 5.8 million, you only have 18,000 people who are either indigent or can't afford. And again, the argument about if you move into the informal settlement and you look at the number of households and people in the informal settlement vis-a-vis the 5.8 population, again, you'll see that mathematically and statistically it doesn't make sense. So there is a problem somewhere that we need to resolve. And we've identified what the problem is, and we've issued clear instruction on how to resolve that matter so that more people can benefit, including the residents in Region F.
Sorry, can you just clarify what instruction have you issued to address the issue?
We did indicate, Chair, that the policy as it stands must be reviewed. It must look at the allocations that are made by National Treasury when they allocate the equitable share to municipalities, because that process takes into account the total population, the poverty index, and it takes into account people who can't afford from a national base. But that data is linked to Stats SA and the system at Home Affairs, which we've written to Home Affairs to get access into the Home Affairs system so that we can get more people into the extended social package, including the residents in Region F.
Would you also accept that the city has an obligation to assist residents who come forward and ask to benefit from the ESP to access the benefits, that the city must proactively assist them?
We accept that, Chair, and we've done that. We can demonstrate the number of, every time we have on a yearly basis, we do community-based planning processes where we go into all regions, we call in Bezos, we go there. In every speech that we make, we encourage people to go to social development to be assisted. When we have open days, when we are dealing with accounts from a financial base, we also extend the services for from social development as part of the team to encourage more people to register. And those that register and don't benefit, we then need to find a way, as an example, in terms of what we are doing now with Region F. So we accept that it's a concern for us as well, that there's less people that are enjoying these packages, which are so designed for them to accept. Because we accept that not everybody is equal. Some people may not benefit, therefore the state needs to provide the social cushioning that we require. So the city is not indifferent to providing additional services to all its citizens, irrespective of where they come from.
Thank you, Mr. Makula. I'm going to move on to the final issue so that we can conclude. And I indicated that we have now received the bad buildings strategy, which was previously omitted from the file. I'm not sure if you have the document before you, the bad building strategy, but you are the author, you ought to be fairly familiar with it. And it's just a couple of high-level questions that I want to put to you on it, having not had the opportunity to work through the detail yet. You've described the bad building strategy in your evidence. You've explained that it's an attempt to be more proactive about the challenges of Region F, and including dealing with the root causes of lack of affordable housing, as being part of the root causes of problems of safety and the other challenges associated with what you call bad buildings. I asked you earlier about the relationship between the bad building strategy and ICHIP, and I see that the document, the bad building strategy, indeed includes a section on ICHIP. It's, for reference purposes for colleagues, it's at page 51, paragraph 7.4, and for the Commission. And in that section, the bad building strategy introduces ICHIP, records that ICHIP was approved by the mayoral committee in 2017, all facts that we've already traversed. Provides a summary of the core principles of ICHIP: a pro-poor approach, partnership approach, practical approach, contextual approach, precinct approach, and promotion of choice. And then states as follows, at the foot of page 51, having stated the above, ICHIP in its entirety is due for a 5-year review. Both the 6 delivery programs and the 5 facilitation programs of the strategy. There is then a figure that, a set of images that summarizes the 6 delivery programs of ICHIP and the 5 facilitation programs. On page 53, the bad building strategy repeats that ICHIP is due for a 5-year review, then states the city has partially acquired the delivery implementation of ICHIP. In summary, the delivery programs the COJ has successfully implemented the following: TEA delivery, social rental housing, and subsidized ownership accommodation. And then furthermore, to date, facilitation programs the COJ has partially implemented the following programs successfully: building, target and release, and special process for the relocation of evictees. So first, I just wanted to get you to confirm the statement there that ICHIP is due at present for a 5-year review by the city, and perhaps explain how that is to take place.
Yeah, indeed, we can confirm that ICHIP, as approved by mayoral committee, had made recommendations for a 5-year review, but we had decided that we need to do that review in line with the bad building strategy and align the two so that ICHIP is not in isolation, because I think we make the point that ICHIP simply deals with the social and affordable housing that needs to be created within Region F. However, the bad building strategy looks at the holistic approach and a 360 view of the problem statement within Region F and how to handle that different from the other regions. So we envisage that we'll do the review in line with as we do the approval of the bad building strategy by mayoral committee and council. We may then start with that review. Again, recall that ICHIP is a program at Human Settlements, and they may also independently conduct the review of ICHIP. But what's important is to incorporate ICHIP into the current bad building strategy, which we had said, it's a pulling together of all of these different strategies from different departments and entities to focus on a single goal of ensuring that people in Region F are provided with sustainable human settlements, both by the state and the private sector.
Thank you, Mr. Makula. One aspect of ICHIP that the bad building strategy doesn't deal with specifically are the targets that ICHIP set for delivery of particular units over time and the costing of those. That hasn't been incorporated or addressed at all in the bad building strategy. So you suggest that it's the holistic approach, but actually that aspect is not part of the bad building strategy. Would you accept that those targets need to be updated and set by the city as part of the review, perhaps, of ICHIP, the 5-year review?
Let's start with the strategy not addressing the aspect of the targets, because if you look at what we are saying in the bad building strategy is that as the city, we may not achieve the amount of units required, and to deal with that is to take some of the properties and give them to the property market to redevelop, because ICHIP suggests that you need to find land in the inner city to redevelop, and of course it's difficult to find land in Region F as opposed to all the other regions. So therefore, it makes it difficult to find the piece of land. And if you were to find the piece of land, it will be outside of the core of the inner city. It will probably move towards Denver, move towards Langlaagte, and those are the areas. And of course, you can look at Terfontein as an example, which you're starting to move outside of the core of the inner city. So what we then said in part of the conversation is, let's rather use the same asset that you have in the inner city, whether it's a parcel of land based on demolition or the land that's already available, particularly those buildings that we own, because there we don't have to find the owner. It's a property that we own, and we will lease that property. Hence, we are asking council to give us those delegations for us to release those properties to the market so that we can then give them to the private sector to redevelop. But of course, we must make sure that the conditions are strict. As a developer, you cannot buy the property and convert it into a commercial space. It has to accommodate commercial, residential, and social amenities that are required. So it's important that, and that's the part. And then, of course, as I said, it's a living document. We want to incorporate ICHIP. It's not indifferent to what we are doing as the city. It is simply providing an alternative way to deal with affordable housing in the inner city. And we are not indifferent to looking at that as part of the review and how we then set those targets.
Would you accept that the setting of numerical targets linked to years and properly costed is an essential element of that planning?
Correct. And we do have those targets in the scorecard of the Executive Director, Human Settlements. There are clear numerical targets on the amount of units that needs to be established and created, whether you're looking at the mega projects, because those projects are linked to a number of units. In order for us to approve a development, we look at the yield in relation to the units that you must provide. If it doesn't give us the required yields to deal with the backlog, we don't approve the development. And of course, we look at the land and who's the owner of the land. If it's the city that owns the land, we then insist on the numbers being increased. As an example, we do walk-ups, and we then approve that walk-ups can be done in the inner city. Those targets are there in the direct scorecard of the ED human settlements.
Mr. Makula, that would be an internal document as between that official and the city. Are the targets also set in any public plan?
Well, look, you may set the targets in the public plan, but how do you monitor that? Because the best way is to monitor it through the scorecard of the Executive Director, which is a performance agreement between the accounting officer and the HOD for human settlements, and they have to deliver on those numbers. You may refer to those targets in the planning document, and I don't think it's something that we may object to. I guess it's part of the review, and while we are going through, because the reason we are going to the other structures is that we may look at additional inputs that the political leadership may want us to add over and above what we've presented. So if that becomes necessary, I don't think we'll have an objection to sort of add those numbers in the name of transparency and being open. I'm sure we can put those numbers in the document.
And as you say, the process of reviewing and updating ICHIP would be likely to include that setting of targets.
That's correct.
Chairperson, those are our questions for this witness.
Yes. Thank you, Mr. Brickhill.
Thank
Mr.
you,
Sidumedi? Any re-examination?
Chair, in all honesty, there is no need for re-examination. I think
Thank
that
you.
the witness was able to.
Thank you.
Thank you.
Ms. Sithole?
Thank you, Chair. Thank you, Commissioner. Chair, if I may, Ms. Matumise indicated that she had to be somewhere for another meeting, but she left me with a number of questions which she sought clarity on, and she asked if I can ask them on her behalf.
No, you cannot do that. It cannot be done. This is your witness now. You have an opportunity to put any questions of clarification. You cannot do the work of Ms. Matumise.
Thank you, Chair. Good afternoon, Mr. Makola.
Good afternoon.
This is an opportunity for you to cross-examine Mr. Makula as per your application to cross-examine him.
Yes, I understand, Chair. Thank you. So I think I'll be quite brief, Mr. Makula, because a great deal of what I also intended to question you on, Mr. Brickhill has covered. So I'll just ask the few questions that I think I still need answers on. So in your oral testimony yesterday, you mentioned the impact of the Blue Moonlight case on the city's backlog, and that the city had to then re-strategize how it looks at evictions and how it responds at evictions. So since the Blue Moonlight case, how many TAs has the city provided to occupiers in the inner city?
I wouldn't be accurate with the number, but I know we had about between 15 and 20 TAs that were provided. But I guess the challenge is around the conditions of those TAs that we had provided and the conditions in those facilities that the city owns. But I can just verify the number. I think they are in the human settlement statement, if I'm not mistaken.
Can you please elaborate what you mean when you say the issue was the challenges around the conditions in the facilities?
Yeah, I think I did testify to the fact that even those TAs that we had provided as the city, some of them have become hijacked. As an example, Moth Building is a building that the city owned. And at the time that we went to do the operation, the building had completely been taken over by colleagues or people who don't own the facility. And as a result, we had to obviously evacuate people from that facility.
Thank you for that clarification. So, of course, subject to confirmation on the number of 15, that would mean the city has only provided 15 TEAs since Blue Moonlight, which is over 10 years to date.
That would be correct, Chair, and I think I did indicate the challenge from a financial resource, and that required us that we revisit the issue of TEAs, because if we proceed with it in the classical form of finding a building and put people in it temporarily, we may not deal with this challenge holistically, which is why we then move towards looking at what Josco, which is a social entity company to provide social housing, to focus more on providing social housing and collect a lot of that rental so that we can reinvest in building additional facilities, particularly in Region F.
Okay, thank you. So you would agree with me that the city has a constitutional obligation to plan for housing in the short term, medium term, and long term, right?
Completely agreed.
Yes. So how many in these 15 TA, assuming that was the number, how many has the city provided without there being an existence of a court order? So in short, how many TAs has the city provided on its own accord because of the need?
Well, Chair, I mean, I can use the flare-off as an example because flare-off, we didn't identify it as a TA, but we've identified it as a social housing to provide to the occupants of the building that we inspected. So I wouldn't generally say we provided 5 or 6 on our court, but I think the facilities that we built through Joshko, we are not identify them as a TA because I can say strategically we do want to move away from a TA, but rather provide social and affordable housing as a resolution to the housing backlog and the challenge, particularly in Region F. Because as I say, in other regions, we build mega projects because you have land, you have the ability to build new spaces. But Region F is a particular challenge that you don't have the piece of land that you require, and therefore the approach has to be different.
Okay, thank you. I think Mr. Brickin alluded to this earlier in his cross, but I just would like more clarity, for lack of a better word. So you mentioned in your testimony that the city has a backlog backdating from 1994, and the urban migration has only added to this backlog. Is the city in a position to tell this commission how much of the current backlog remains part of the backlog dating from 1994? I'll qualify my question. I ask this because on previous occasions before this commission, the city has repeatedly mentioned the idea of an existing queue and people jumping the queue, particularly in reference to TA. So what I'm trying to gather from you is how long is this queue and how far are we moving in terms of the queue, if the queue exists?
So the queue does indeed exist in terms of the housing backlog, not necessarily the TAs, because TAs is an intervention to try and release the pressure on the housing list. If I'm not mistaken, Chair, and I think we just need to verify that information, we still have about a 60% backlog in terms of just if you go into the 1994 list, because this we had to go back and revisit in the recent month after we had the backlash from citizens in Soweto to look at what is that list in terms of the 1994 RDP list. And we found that we still have not moved beyond 70% in terms of that number. So that creates a whole lot of pressure from human settlements. And what it means is that we do need to accelerate the implementation of the mega projects, particularly in this one, I think about Southern Farms, which has been approved for the last 2 years and is currently in construction. And we do need to complete that because that will reduce, if you look at the number of units that are going to be approved, is important for the city of Johannesburg. The other one is the one in Protea South, Masingita development that we've already approved and it's in construction. We are working with DBSA on the infrastructure. This will also release pressure within Soweto for those particular units.
Okay, thank you. So you've spoken about Moth, I think, a great deal, and you've just mentioned that Moth was a TA that got unlawfully occupied. When did the city come to a realization that it's lost control over the Moth building?
So I think if I recall in the part 1, I think it was almost 5 years that the city lost control of the facility completely through the Johannesburg Property Company.
And in your testimony, and I'm sorry, Chair, I don't have the paragraph reference, but you mentioned in relation to Moth, you mentioned that the court gave a directive on the evacuation as well as meaningful engagement. When did the city receive this directive in relation to Moth?
I wouldn't be aware of the date, but at the time that In 2023, when we were planning the operation, of course, one of the things we needed to take was to ensure that legal had gone back to court to satisfy the conditions of the court and also submit an operational plan from our side. So, like I say, I'm not sure of the exact date, but I got the assurance from legal. We even got the court papers to support the submission from legal.
You got the assurance in 2023 when you resumed as COO?
Well, we can say that when I obviously started planning for the operations as part of the submission from legal, but I'm sure the group head legal can be able to provide the detail on when we received the evacuation order for those 3 buildings that are in my statement, including Florence.
So if, as you say in Part A, we're estimating that the city had known for about 5 years about the issue of moths, and by the time you took office in December 2023, you got confirmation from legal of the court order. Why did the city only evacuate Moss building in December 2024, specifically after this commission had conducted its inspections on buildings, including Moss building?
Yeah, Chair, it may be difficult for me to respond to why the implementation was not done at the time. I'm assuming there were a lot of operational challenges that the city needed to prepare. I suppose the issue of temporary accommodation is the one that really stands out, because in the engagement with my colleagues, when I try to understand the work that we are doing, because part of designing the bed buildings did not just include let's go ahead and do 1, 2, 3, was to understand what challenges did we have, what are the backlogs, and how do we ensure that they do not repeat moving forward. So I wouldn't be accurate in saying I know why the challenges were, but what I know is we got involved in how do we resolve the challenge moving forward. And of course needed to make sure that we tick all the legal boxes before we proceeded to do the operations.
So, considering everything you're saying, I put to you that Moss was only evacuated last year in December, only because this commission is in progress and the commission had inspected the building with the city. And if this commission did not exist, then the city would not have evacuated Moss, which it knew about its problems for at least 5 years, as you say.
I wouldn't agree with that, Chair. Again, it's a question that I responded to, that the city does its work on a regular basis. People are appointed in positions to do their work. At times, the work may not be effective or efficient, and that requires that from a management perspective, you need to review and revise your operational plan to ensure that you get maximum output. And again, I refer back to, if you look at the city's long-term plan, which is the growth and development strategy, it recognizes that we do need to create affordable housing in the region, in Region F and in the city, and we do need to deal with bad buildings, we do need to deal with bylaw enforcement, and these are also simple issues of lack of bylaw enforcement or inefficiency in enforcing the bylaw. It may seem like that from a general point, but it's part and parcel of the work that the city is doing on a regular basis to try and alleviate this problem. So I wouldn't necessarily agree that we are doing it because the commission had been established and there were inspections that were conducted. I'm aware that the commission that did a number of inspections, not just these buildings, but on other buildings which are part and parcel of our plans to move into that space and regularize and normalize that environment or that space.
Thank you. So you mentioned that there was a backlash from the Soweto community when you tried to evacuate the people from the Moss building into Vlehof. I may just have missed it, but for clarity, currently, because in the testimony it says the building is cordoned off, where are the people from Moss? Did you ultimately resolve the backlash? And are they in Vlehof or are they elsewhere?
They're in Vlehof. We moved them to Vlehof. We gave them units in Vlerhof. They are currently in Vlerhof, and we had to deal with the backlash and not succumb to the pressure of those facilities being either invaded by the citizens as they had claimed on social media and all other platforms.
On the backlash from the community, as part of evacuation or other relocation processes, the city is required to engage not only with the occupiers it's moving, but with the receiving community. In this case, did the city engage with the community of Vlerhof to avoid the issue of the backlash?
We did, Chair. If you look at where the complaints were coming from, we're not coming from the citizens within Vlerhof. It came from citizens in Soweto who actually are a distance away from where these units are built. So we did that. We said part of the initial step is to do an assessment, do consultation processes from human settlements and Joshko into those areas. We also consult ward councillors, we consult with ward committees in relation to the work that we need to be doing and what the intentions are. As an example, Chair, I referred to the other delay was we wanted to move the people in Moth to Tefontein, and we had to do an assessment. And when we did the assessment, the communities of the area that we had identified had indicated that they may not be comfortable with the reallocation because they have established the township, and therefore this may impact on their livelihoods, and we need to find an alternative venue. We found Orange Farm as an alternative. Again, that became an issue because the taxi owners had said, look, we've identified this land for something else and you can't move. So we do the consultation and then deal with the outcome of that consultation.
Thank you. Now, moving on to the workshops that you said yesterday, well, it's not clear on the statement, the timeline, but in your oral testimony, if I got it correct, you said the workshops ran from January 2024, because you only commenced in December 2023, all the way to August 2024, and that they included relevant stakeholders. I think there was mention of SERI. What was the criteria of who qualifies as the relevant stakeholder?
So there was no specific criteria, Chair. So firstly, we used we have what we call in the institution the Inner City Partnership Forum. And that forum includes all stakeholders, NGOs, business, owners of properties, security companies, and. So we use that platform and that database to extend the invite. It will include academia, UJ, VETS, and all other institutions. So we sent the invite through that process, but also we didn't limit it to any other. That final workshop was to really get inputs from external stakeholders, because the first 4 that we held was more inwards focused, and we needed to ensure that internally we all move from the same base before we bring external service providers. So there isn't a real criteria. It was not really exclusive in that way, hence we've agreed. I mean, there were other institutions in there that were not necessarily invited by the city, but we didn't have an issue with that because we wanted more inputs from all the external stakeholders to make this strategy much more effective.
And in those other stakeholders you mentioned were not invited, the Human Rights Commission was not invited either. And I would argue that it ought to have been invited given its constitutional mandate, but it was not. So you had the workshop which had the voice of everyone, but the person with the constitutional mandate to protect and promote and monitor the observation of rights. So just to move along, at paragraph 29 of your statement, you mentioned that the property bylaws have not taken off because you received legal advice regarding ongoing litigation about the bylaws, and that it would not pass the constitutional muster. Can you give more details about this ongoing litigation regarding the bylaws and their constitutionality?
Chair, I don't recall that we said there's pending litigation. What we said, we've received advice that there's a clause in the property bylaw, the clause related to the expropriation of those properties, those that are owned by the private sector, may impede on the constitutionality of the owner of that property if we expropriate that property. And we did say that GFIS continued to enforce the certain aspects of the property bylaw. But of course, we had consultation on whether we can continue to implement. It was really an advisory. It didn't say that you have violated someone's constitutional right. The law firm was worried about that clause in the bylaw itself. But the bylaw had already been promulgated by council in 2014, and GFIS was using that bylaw to then investigate and provide us with information about the property, problem properties in the inner city.
So the issue of expropriation, it doesn't come out from the written statement. It came out on your oral statement yesterday. The second sentence to paragraph 29, it says the city received legal advice regarding ongoing litigation relating to the issue of the bylaw on problem properties. And that's the litigation I'm asking about.
Yeah, Chair, as I repeat, there isn't litigation currently on the problem property bylaw. It is advice, legal advice, that you may be litigated against because of that the unconstitutionality of you expropriating those properties. And that's the legal advice that we've received.
So that would make this sentence incorrect.
No, on which page?
Page 46, paragraph 29, the second sentence.
'56.
46.
46. Sorry, my apologies.
Second line.
'46 on, just repeat that, Chair.
It's
My
paragraph,
apologies.
page 46, paragraph
Yes.
29, the second
29, yes.
line. It starts with, the city received legal advice regarding ongoing litigation relating to the use of the bylaw on problem properties.
Yeah, Chair, so the understanding at the time when we made the statement that was that there is not necessarily on the city's bylaw. There is currently litigation related to the release of properties or the expropriation of properties without compensation. I recall that specific conversation. So the legal team was saying if you were to implement the clause related to the expropriation of those, you may also be contributing to the ongoing litigation in general in relation to expropriation of property and land without compensation. And that's the conversation that was happening. Not that there is a current litigation that the city is under at the moment based on the problem property bylaw, because we had not started to expropriate properties. You recall that I referred to through the rates, the credit policy, we had anticipated that we will do sale and execution, but we had actually not moved beyond that point. And that's where we were actually going to, through the revenue collection strategy, to try and sale and execution on the basis that you have not paid your bills on your account.
Okay, thank you. That's as far as I need to take that point. So you also mentioned that the bylaws are in the process of review. So when did the review start? We know the bylaws are from 2014. When did the review start? And how far is the process of the review?
At this point, at the time when we made the statement, I subjected the bylaw again. The team GFIS submitted the revised bylaw, but I was specific that we do need to subject them to a legal review before we submit them through the governance processes for the final approval. This was about, again, just before we went into the operation. I may have to check how far it is now based on the legal advice that we've received. By the way, the legal advice had since changed, but I generally don't want to get into that at this point.
So when did the process start?
The process started before my arrival. So at the time when I arrived, the review process had already started. The only way I was concerned about was which specific aspect of the bylaw is maybe unconstitutional or is unconstitutional. And that's the part that I engaged with GFS on. And I then asked the question, if I recall in the workshop, if only one aspect may be found unconstitutional, why are we then delaying the review of the bylaw based on that legal advice? Maybe let's test it and put it to the test. I even recall saying to Group Head Legal, go and expropriate one property and let's see what happens from there, whether it's constitutional or unconstitutional, because there's only way to find out is to actually proceed, but follow the legal process, and then we'll defend the action if it's illegal. But of course, at this point, I still don't believe it's illegal or it infringes on any person's right, because they would have not paid for their services. And if you look at the value of the property vis-a-vis the amount that the property owner owes to the city, one can obviously offset one of the other, but you do have to follow the process. As I say, you must just test that out in the courts, I assume.
Thanks. So Chair, I had one question about the bed building strategy, whether it includes implementation of the property bylaws. That was before I received a copy of the annexure that we don't have.
Yes.
So I'm not sure if I can ask questions that I have based on the annexure, or
Yes, you may. Mr. Brickhill has.
Okay. Thank you, Chair. So I have
Mr.
a
Sidumedi.
Yes, Chair, I just want to clarify my colleague, my apologies. During the lunch break, I did forward Mr. Brickhill a full set of this strategy. The document that my colleague speaks to is, you can use it, but it is an input from human settlement into the bigger document. It is only that clarification, Chair, that I wanted to.
It's not the correct document.
It is not the actual document. The document is that Advocate Brickhill made reference to is quite an extensive document, not this
Yes.
slide. That's the only clarification.
Yes.
But for a record, this document is a human settlement document as an input to the bigger document.
Yes.
That's all.
Yes, you may proceed.
Thank you, Mr. Dumedi. So
With that understanding
yes,
that it's a sub-document of a bigger document.
yes. So Chair, I'll just ask questions based on the one that I have. So it's titled bed building methodology / strategy, city perspective. And unfortunately, it's not numbered, but and I can't even count the pages. But there's a page on that says some priority bed buildings. If you can page and just get to the page with that title.
That says what?
Some priority bed buildings.
Yes.
Yes. So on this page, the city lists the buildings that it says it has identified as priority buildings for immediate resolution. Are you able to clarify for me what the city means when it says resolution in this case, in the case of these buildings?
Yeah, to my understanding of resolution means, of course, taking the action to inspect the building, ensure there's compliance, comply with the evacuation of the occupants, and redevelop those facilities. That would be my understanding. But I suppose the AD Human Settlements can really give you a precise response to this, because this is their document.
Oh, okay. So if we are to take it as though, well, let me rephrase. These buildings have been identified. What was the criteria? Do you know the criteria that was used to identify these particular buildings for immediate resolution?
Chair, I'm going to respond at really high level. And again, I think the ED can be able to respond. So criteria one, of course, is that these buildings would have been investigated by the Group Forensic Investigation Services and identified or categorized them as problem property buildings that requires attention, mainly because they don't comply with the city's bylaw, whether you are looking at emergency services, building control, environmental health. Others could be that there's also illegal water and electricity connections. So it is a myriad of criteria that you would have used, but I suppose human settlements can. But really at high level, if you look at the strategy, because this was an input document, we would look at all of those aspects of the bylaw that's related to the problem properties, and then we'll identify them as a priority to be resolved.
Okay. I appreciate that your response is at high level, and we'll get the opportunity to ask the executive director when he comes on the stand. But what I want to know is, how is it that some buildings made it to the list if we are to accept that high level criteria that you just mentioned, while others didn't? I'll qualify my question. During the inspection, the commission inspected a number of buildings. Included in these buildings, I think it's 52 and 54 Super Road. And the conditions in that building, I would argue, is far worse than in any of the buildings that are listed here for immediate resolution, and would meet the criteria, the high-level criteria that you just mentioned. So I'm wondering to myself how such buildings then did not make it to the list of identified priority buildings. You don't have to answer that, Mr. Makula. We can take it up with Mr. Nkwani when he comes. But I thought I should just mention it. So I'm just going through my questions because some of them, Chair, have been
Mr.
asked.
Tole, you must be alive to the time allocation that you requested.
Yes, Chair, I am. I'll be finished quickly. So at paragraph 38 of your statement, so I don't have the file, so I don't have the page reference, paragraph 38. And I think you've said this in your oral testimony.
Yes.
Yes, you say that human settlements' long-term strategies to move away from TA to affordable housing, which I agree with, and that human settlement is considering utilizing the vacant land that it owns. Is there any existing vacant land owned by the city in Region F or in the surrounding regions?
Chair, there is land that the city owns through Johannesburg Property Company, but as I had already indicated, that the challenge is that bulk of that land is not in Region F. It's not within Region F, which presents a separate challenge in terms of constructing mega projects that I refer to, whether it's Allendale, South Hills, South Rand, and Tanganani, because there we have the land and we are able to build much more units, but not in Region F, no.
Oh, okay. No, thank you, Chairperson. Thank you, Madam Commissioner.
Thank you,
All
Mr. Tole.
from me.
Advocate Chimenya, would this be an appropriate time to adjourn until tomorrow before you commence? Oh, before that, Mr. Sidumedi, I dare say you don't have any re-examination.
Definitely, Chair.
Indeed, Chair.
I think this would be an appropriate time to adjourn until tomorrow. Mr. Makola, you are still reminded that you are under your former oath.
Noted, Chair.
These proceedings are adjourned until tomorrow at 10 o'clock.